My lord, the items lordship is heard on 13, 14 on 25th. Two second appeals. Yesterday, the appellant has submitted the item. Today, in counter, I am submitting his statement. Continue.
May I please, Your Lordship? My lord, I am praying on item number 23, the part third hearing matter, my lord. As per the last direction, I supposed to be file additional affidavit with sketch map, but my lord, we have applied for the sketch map yet to get that copy. So I'm praying for some time. I have taken consent on that side. It is 4 weeks. my lord.
Data learning for the dictionary.
Appellant.
Appellate. That's the matter on
September. Yes.
May please, Your Lord.
Deep look.
Item number 18, my lord. I have consent on the other side, my lord. Could it be taken up on any other day? As convenient.
after 1 week.
Yes, yes. Any date may be fixed. After one.
May I please, Your Lordship? Lordship, this one civil revision, Lordship, I filed today. Just praying for taking up the matter tomorrow, Lordship. The date is fixed on
Not possible.
Monday, Lordship. Then on Monday, Lordship.
Monday.
Please, Your Lordship. Sir, I beg to mention for listing of one RSM matter, Lordship, because since 1 year, Lordship, this matter has not been listed, Lordship.
What do you want?
Lordship may kindly take up this matter any
Take it
in the next. If may please, Lordship. I would like to mention for our listing of a MSCP with IA, Lordship.
When?
It's a long pending case. So it was last posted on 2021
When do you want?
for orders. May please, Your Lordship. I beg to mention item number 28 with the consent of other side.
My lord, I have no objection, but a date may be fixed, my lord, as per convenience of your lordship. Any date, any month, my lord.
For 28.
Yes.
A date may be fixed, my lord.
On the affair being made by Mr.
See, look that.
Learning Council for the appellate.
Yes.
That is the matter. Or
Any day, convenience of the court. Highly obliged.
Yes, please. I beg to mention on CRP. For CRP, my lord, matter is very urgent. I'm praying for listing of this matter on Monday, my lord.
Monday.
Monday, my lord. Wednesday, that trial court date is fixed, my lord. That's why I'm praying for listing on Monday, Wednesday. Tuesday.
I please, Your Lordship. Lordship, my prayer is for listing of CRP only.
When?
13. Why? My Lordship, it has came on, last time it has came on 2019. So it's been a long time. On 13.
Yeah.
May I please, Your Lordship? I beg to mention item number 25, Lordship. In the consent of other side, kindly adjourn for 2 days. Lordship, a short date may be fixed. 14th of August.
Lordship, I am for respondent number 4, Lordship, in item 25. Our name may be strike off from the causing, Lordship. Our instruction to withdraw the wakalat number, Lordship.
Lordship, 14th
Roy-
August.
Please, Roy.
On behalf of T.S. Hazarika.
Learning Council. Yeah. There may be record as they have already done the color number. There is out that
Lordship, any date in August, Lordship.
May I please, Your Lordship? I'd like to mention item number 15, Lordship. We have filed an additional affidavit today morning, Lordship. May be called for, Lordship.
15. Okay.
Obliged.
Lordship, with the consent of the other side, Lordship, beg to mention item number 30, Lordship. What happened in this case, Lordship? I am the pro forma respondent in this appeal, Lordship. However, Lordship, I have also filed a similar appeal asserting the same judgment. And the same, some 27 days delay occurred. So notice on delay was issued by this honorable court. May I pray that both the matter may be tagged together and come up together, Lordship.
No, I am for the appellate, my lord.
I
It
will
was a
inform.
joint decree, my lord. He is one of the affected party. I am the other affected party, my lord. We have filed preferred separate appeals. So let that appeal be also be tagged, my lord. I number two.
May please, Your Lordship. Lordship, I am for the respondent number 2, Lordship.
Lordship, today's matter is fixed for the disposal of the IA, Lordship. And the matter has been fixed today. Lordship, maybe it may be heard, Lordship, today. And disposed of accordingly, Lordship. Because they have filed a petition which we have, accordingly, we have not been complied with. And this may,
That matter is not before the court today.
yes, Lordship. But
Let both the matters come together.
today's matter is fixed today for,
Today it is for hearing, my lord, not
Yeah.
for consideration of the, it should have come up for consideration of the IA, my lord, stay petition. The appeal is admitted, the my lord, decree has not been stayed as yet.
Why?
My lord, it was, notice was issued, they have appeared.
we have appeared, Lordship.
First appeal, regular first appeal.
The IA has been fixed for the stay of the order dated 15 dated 5/11/2024, the judgment and decree, Your Lordship.
Okay, on like that we'll consider both the appeals.
Let both the appeals come together.
What is the number of
Lordship, IA civil 1189 of
the other appeal?
IA civil,
I condonation, Lordship.
IA civil number
1189
1189.
oblique 25.
This is the appeal
Amla.
of IA.
More than I think.
Oh.
Whatever.
Ashok.
May I please, Lord? We have filed an IA for releasing of the check, Lordship. This matter may be taken up on Monday.
Monday.
May it please your lordship, with the consent of other side, I beg to mention item number 29, lordship. Lordship, the matter may be adjourned for the day.
Sir,
A Singh, lordship. I'm for the appellant.
you inform the other side.
Yes, lordship, I have informed the other side.
After a week,
Bless.
yes.
May I please, Your Lordship, WPC 4275/2023, may I pray for listing this matter? The subject is for settlement of land.
Not before this court. Then,
The civil bench file will,
what do you want?
11/8.
11.
Yes.
This is not a bench on matter.
Yes, but that bank.
Go to the 11.
May I please, Your Lordship? Your Lordship, listing of into MSc appeal, one for admission and another for a stay vacating petition was not disposed of. And it was listed last time on 2/9/22,
What do you want?
as Your Lordship pleases. This is for orders and another for admission. Oblige, Your Lord.
May I please, Your Lordship, I beg to mention item number 37, Lordship. Finally, the matter may be passed over for the day, Lordship.
Appeared by that the matters that's over.
Your Lordship, I also beg to mention one RFA for listing in orders column, Lordship. Can it be on Monday, Lordship?
Monday, not possible. Any other?
Obvious. Your Lordship, as telephonic instructions received, kindly the matter may be withdrawn, Lordship.
But your name is not there in
Yes, Lordship, I am appearing on behalf of R. Chaudhary, Lordship.
the Also, that's fine. There- Once, so the-
Okay.
Made procedural lordship. Before taking your lordship the impugn order, my lord, I'd like to give the actual background, my lord. Lord, what has happened, my lord? The petitioner before your lordship, my lord, it's a public sector undertaking, my lord. It had entered into a contract with the respondent number 2, my lord, several contracts. Now disputes arose between the respondent number 2 and the petitioner, and arbitration proceedings are pending, my lord, where they have filed a claim of around 400 crores. We have also filed a claim of around 50 odd crores. Now, in the meantime, my lord, the respondent number 1 filed a suit against the respondent number 2. There a decree was passed where, my lord, certain machines which were of the respondent number 2, which were lying in our premises, my lord, those have been attached. We are not parties in that suit. Now, execution notices were issued. We filed our objections, but the learned trial court has held that no, since the materials are attached, they are going to attach and sell it, my lord. Now, what has happened in the meantime, my lord, the respondent number 2 went into liquidation, my lord, under the Insolvency and Bankruptcy Code. There, my lord, if your lordship kindly turns to page 37.
No, where is the impugn order?
Impugn order is at page 101, my lord. What I am on, my lord, the entire execution proceeding is without jurisdiction because it was instituted when the moratorium under the IBC was in force, my lord. In fact, the main petition which I had filed, that has not even been considered, where I had raised all these objections regarding the moratorium, regarding the going into liquidation, that has not even been considered.
You have been given sufficient opportunity before the court fellow.
Lordship, I am coming to that.
Up to page number 1.
All right, I'm coming to that. Lordship, will kindly take up page 37, ma'am. Because that decree cannot be executed now, my lord, in view of the development.
Page number
Page 37. My lord, respondent number 2 is Jai Hind Project. Who is the judgment debtor? My lord?
Yes.
Now, one SKE Projects Private Limited has instituted a proceeding for liquidation, my lord, of that company under the Insolvency and Bankruptcy Code. This is an order passed by the NCLT Ahmedabad, my lord, dated 2/11/2018, my lord, where moratorium has been declared, my lord, in respect of the properties. Lordship would kindly come to page 44.
Yes.
Lordship has got it. That this bench, subject to provisions of subsection 2 and 3 and 4 of 14 of the code, hereby prohibits the institutions of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, or order in any court of law, tribunal, arbitration panel, or other authority. This is 2/11/2018. Now, when the moratorium is in force, the execution case has been filed. On 26/3/2019, my lord, I have made a specific statement in my petition.
In which paragraph the next?
Paragraph 16, my lord, at page 9. And not only this, my lord, after this, the resolution plan has been approved, my lord. Lordship kindly comes to page 59. It's an order dated 19/3/2020, my lord. Lordship has got it.
Yes.
Lordship turns to the conclusion part at page 84, para 30. Last paragraph, madam. Under such facts and circumstances, we, the adjudicating authority, is of the considered opinion and also being satisfied that the resolution plan as approved by the so-and-so meets the requirements as referred to under subsection 32 of the code. However, one of the dissenting financial creditor made an objection with regard to the disparity in the distribution of amount in pro rata basis and amended so-and-so. As already is, we are of the opinion that for this small issue, the plan cannot be disturbed. Also, the other financial creditors are directed to contribute on pro rata basis as per their proportionate stake debts to the Axis Bank, so that comply with the newly amended so-and-so. Axis Bank get at least 8.6 crores, if not fair amount of 15 crores to meet our so-and-so. Ultimately, it is approved, and one of the creditors had objected. That has been looked into, but the resolution plan cannot be disturbed. That is at the second subparagraph. To meet out such objection of the Axis Bank, and as per our financial creditors have not approached this adjudicating authority as such, COC financial creditors shall convene the meeting to resolve this issue without touching the other parts of parameters of the resolution plan within the period of 15 days from the date of availability of this order online. Now, my lord, the apex court has clearly held that, my lord, when the resolution plan is approved, my lord, anything beyond the resolution plan cannot be executed. I have given the judgment, my lord. I have given the book, my lord, 2021 9 SCC, page 657. I have given the judgment in the petition itself, my lord. At page 18, my lord.
Where is that resolution plan?
The resolution plan is not part of the requirement. We could not get to the order approving the resolution plan is there. Now, I have made a specific statement that I have gone through the.
How can this court ascertain whether?
Yes, my lord. Yes, Lordship is correct. Kindly come to the order approving the resolution plan. ठीक है, पहले। Kindly come to page 77, madam. Madam, this chart of paragraph 23, madam. This chart shows the assets of the company in liquidation. That is the respondent number 2. Lordship kindly turns to page 78. 78 in the middle portion, location 4. Assam not visited. So as per the resolution plan, the corporate debtor, the respondent number 2 does not have any property in the state of Assam. Now, Lordship comes to the judgment which I am relying upon, madam.
Can you place on record the resolution plan?
My lord.
Can you place on record the resolution plan?
My lord, it is difficult because we have downloaded everything from the website of the NCLT. That resolution plan is not there, my lord, uploaded. The order is there. My difficulty is that the case is fixed today before the executing court. The Nazir is coming daily, my lord. The issue is that we have got a counterclaim against them. And I have made a specific statement in my petition that my lord, they have not gone before the NCLT. We have gone before the NCLT. NCLT has given us liberty to raise our claims before the arbitral tribunal. That order I have annexed. Because they have to submit the proof of claim before the adjudicating authority. Only when the adjudicating authority approves of the proof of claim, my lord, that either it is settled or it is included in the resolution plan. Just for a moment, if your lordship takes up the judgment which I am relying upon, just for a moment. It is 2021 9 SEC 657, para 102. At page 716, the conclusion part. Lordship has got it, madam. In the result, we answer the question framed by us as under. That once a resolution plan is duly approved by the adjudicating authority under subsection 1 of section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtor and its employees, members, creditors, including the central government, any state government, or any local authority, guarantors and other stakeholders. On the date of approval of resolution plan by the adjudicating authority, all such claims which are not part of resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect to a claim which is not part of a resolution.
But unfortunately, that resolution plan is not specified.
But from the order, my lord, lordship can at least ascertain that there is nothing in Assam of the company. So how can, in execution of a decree, something lying in my premises which is not part of the resolution plan can be attached, my lord? I am not a party in the suit. If your lordship takes up the judgment which is being sought to be executed, my lord, kindly come to page 25, my lord. This is the judgment which is being sought to be executed, my lord. Plaintiff is FJ Trading Company. and the defendants are Jai Hind projects. I'm not even a party in this suit. In paragraph 16, my lord, I have specifically stated that the respondent number one has never approached the NCLT. I have approached various other authorities and parties have approached, my lord. And from the resolution order approving the resolution plan, it shows, my lord, there is nothing in Assam. If there is nothing in Assam, my lord, in the resolution plan itself, order, how can that property be attached? And when, as per the contract, I have a lien and arbitration proceedings are pending, my lord.
Whether you have placed these materials before the executing court.
My lord,
Have you placed these materials before the?
no, materials are not such that can be taken there, my lord. These are machineries. My lord,
The documents you have relied upon before this court, whether you have placed those.
lordship will kindly come to the petition which I have filed, which have not been considered. Page 88, my lord. Kindly come to page 90, my lord. All facts have been pleaded, man. From 89, the entire facts 89, then lordship turns to 90 that there are subparagraph Roman 4, the pending arbitration proceedings. Then paragraph 5 that the company went into liquidation. Insolvency is pending, my lord, under section 14. Moratorium has been issued. And the 19.3 approved the resolution plan of so and so. This has not even been considered, my lord. That's the part. This petition has not been disposed of. It is still pending.
Why it was not disposed of?
That, my lord, I cannot say, my lord, because this was filed on 4/1/2025. It has not yet been considered.
Is there any mention about this petition?
No, there is nothing, not in the impugn order. But that this has been filed, it has been recorded by the learned court below, my lord. Kindly turn to page 97, my lord. Court on the next date clearly records that we have filed it. The court, the presiding officer was absent on 4/1. On 8/4, it is recorded that we have filed that petition.
Let this petition be passed or disposed of by the executive court.
Let it be disposable, lordship may direct, at least till then they will not go ahead with the attachment execution, my lord. And we may be given the liberty to, because although pleaded, my lord, some of the orders were not placed. We will file a fresh application. Let the court decide. Let this petition be kept pending, my lord. And till then, let them not execute, my lord. Because if the properties are taken away, I have a counterclaim. And I am not a party to that suit. The whole issue is, my lord, the execution.
What is maybe attached by the civil nazir, where the civil nazir will take the property.
No, they have come to take the property.
Oh.
The Nazir. They will take the machinery and they will auction sell it, my lord. And my case is that this whole case, the execution proceeding is absolutely without jurisdiction. Let the trial court decide my petition then, my lord. 4/1. It is till then, let them not execute. Lordship will fix a time frame, my lord. We do not object to that.
I will go to the record and pass the order.
My lord. My lord, only prayer is, my lord, that the case is fixed today, my lord.
I will pass the order today.
Today, oblige,
But
much
before
oblige.
passing the order, if it is executed, then
Of course, my lord, that is there. But that is there.
Number 1 and 2. Lordship, one lordship.
is there any chance?
Lordship, they are connected appeals, lordship. So no chance, sir.
No, sir.
No, sir. Because he is the appellant in one case. He has a issue on permit. That is against
Then,
quantum.
let us fix the matter for hearing.
Yes, lordship. Definitely.
Heard Appellate. And also heard the and 6 club heard and for the appellate and the appeal number 25.
25.
The Ahmed heard and 4
1, 2, 3, and 4.
for the appeal.
Lost.
For the appeal.
Yes.
Good.
So the matter is listed under the column the subject part and accordingly it provided that both inspectors for hearing
Order may be given, lordship.
Obligers.
Unlike.
Here.
Here.
Or here.
My lord, my lord claimant, one is my lord suffering from my lord kidney problem, lordship. So he
What's
needs
it?
money, lordship.
I can make the plan. Obligers.
Obligers.
Here. This case will fit for mediation, lordship. In fact, lordship, we have mentioned it for hearing because 2015 matter. A lot earlier occasions may not be possible, lordship, for mediation settlement.
earlier it was referred to the mediation.
No, earlier, although we have made some discussion, but it is not possible. So many issues are there in it.
Okay, then we will fix the matter for hearing.
My lord, I am praying for.
Okay. Third and third.
A and thus
A and the third
respondent 1.
number 1.
1.
You. It is subject at the bar and do the matter that under the column. Platform is the matter for hearing.
Any
Is the order 15 minutes.
15 meters.
Second
Bless. Number 4.
Please, your lordship. Hearing, my lord, what has happened in this case, my lord, I've informed my lord on 26/7/2024, my lord, that my lord, the claimant appellant, the respondent has died, my lord. But till now, my lord, they have not filed any substitution application, my lord.
Lordship, the details of legal heirs have not been provided to us, Lordship. And more so, Lordship, by the order dated 26/7/24, we are directed to take steps upon respondent number 2. But after the report came, we came to know that respondent number 2 died.
the particular
My lord, right now, I do not have, my lord, I will furnish the details, my lord. My lord.
And Lordship, they may allow us to take steps upon respondent number 2 by dusty upon the legal heirs of respondent number 2, Lordship. Because he died.
entered is set under the column referring to pension. Is there chance or not?
No, I don't think so, my lord. Don't think.
So Lordship may pass an order
And my-
to provide my learned friend.
That I will furnish, my lord. And one more thing is there, my lord, while admitting the appeal, my lord, they have deposited 50% of the awarded amount, my lord. There is an order from the registry, my lord, on that IA number 2706, my lord, your lordship may kindly see that order, my lord. That next to that file, my lord, there is an IA, my lord. 2706. There is an order that, my lord, since, my lord, they have deposited the 50% long back, my lord, on submission of the next to kin certificate, my lord, with permission of this court, my lord, the legalists may be allowed to withdraw that amount, my lord.
Number one.
একটু order আছে এখানে কইছে তোমার দরকার নাই তাতে my lord there is an order of the registrar general, my lord. Lordship may kindly see the order, my lord.
So I don't know how the substitution, that order can be passed.
Order to file. That notice has been issued long back, but I was waiting for the application for
And they have
substitution.
not provided us even with the details, otherwise we could have done the.
But there is an order
substitution.
from the registry that, my lord,
That
on
is totally
submission of
ignorance from the side
yes,
of the
but
claimant
point,
side.
on submission of the next of kin certificate, your lordship can allow us to withdraw that amount, my lord. But it's lying since long time, my lord. There is an order to that effect, my lord, specific order, my lord. I will furnish them the details, my lord. In the meantime, my lord, I may be allowed to furnish the details and do that amount, my lord.
There is already an order. Why should I pass it?
My lord, in the last portion of that order, my lord, there is that specific order from this court is required to that effect, my lord. On submission of the next of kin, that I may be allowed to withdraw, my lord.
It has already been approved by the registrar general.
Yes, my lord, but in the last paragraph, my lord, it is written that, my lord.
Where?
In the last paragraph of the order, my lord, for order of this. That's incorrectly, my lord.
Further order. Okay.
My lord.
Third, third, what? Go for it.
My lord, one, my lord.
Number one. Who suffered payment?
Yes, my lord. I don't, that I have informed on 26/7. So, my lord, died on 5/6/2019, my lord.
Number one. Who died? Respondent number two.
Respondent number two died, that we took step.
Suffered payment. Or
One is
One को रुका है तो two रुका है.
okay. Who is the owner, my lord? I am not appearing for two, my lord. Only one is the claimant, my lord.
who died?
My lord.
One died and two also died, lordship.
Right, my lord, I am not appearing for two, my lord. Two is the
Who is the
owner. I am
owner?
appearing for only claimant respondent number one, my lord.
So we may be allowed to take steps upon the legal.
That he may file, my lord. I can only give details of one, my lord.
Yes.
Claimant. One died on 5/6/2019, my lord. Claimant.
Number one died on 5/6.
2019.
And number two also died.
Yes,
my lord.
That's a formal learning of you take rest.
Why does the lord?
Take care of the number. Then let's go allow check the
रिपोर्ट से है क्या ऊपर जैसा लो
provide detailed particular of the lesson number one or one. Or when you will be back.
Well, I will give him the details, my lord. I have to collect the information, my lord.
Also, 4 weeks time will be granted because it's dusty, so some time will be required.
One week from
My lord.
referring the order. It
16.8 perhaps.
is option of this.
24 mile.
Order of or what was the date?
Okay, it is 26.7 perhaps.
Date 2019.
Mile.
I heard of 2019. The applicant deposited 40% awarded. Then
Deposit to which
the order of that,
only order. One notification to the
the
date on the
30, that of the 30 of the and there already about it was not stated. There is according to law. On fronting the age certificate act. For all both it is subjected for the letter. One.
Number 5.
My pleasure, Lordship. We are ready for the debate. We are ready. to vote.
Yes.
We have no objection, Your Lordship.
Or
As done then.
Appellate appellate two. And the other for the respondent number
5.
The claim for respondent number 2.
respondent number
Two.
Sir?
Yeah, sorry.
Yeah, certainly. And you?
ABN. Your Lordship, ABN, she's appearing with me.
Okay.
But there are two insurance companies. Vehicle was involved. The award was proportionate 75 to us, 25 to
And
them.
25 to us. Lordship, the grounds of appeal are only on
There are
quantum.
some for settlement in the mediation.
Lordship, there are grounds of appeal is on quantum. Quantum. So
Can be taken off.
it may be taken to.
There is none. Okay. After that, the bar. That there is thing to be there that is the method is in the third one of them. For reference, mediation for the next. And it is subject to the bar. That there is not to settle the method of mediation. According to the method referred what the this is the method of the mediation. And further directed appear for the mediator, but a good mediation method on other side.
When
Well, both the party will appear for the mediator.
20 of
yes, ma'am.
20 August,
Yes.
mediator till 5. But before this 40.
Of less.
number 6. So, mediation जहाँ पर okay, you to go.
My lord, in this case, my lord, there is no chance for mediation.
Fix for hearing.
Or the appellant at the state of the or
1 and 2, my lord.
I am lordship 3 and 4 lord.
you also
3 and 4.
your name
But
please
DK Das on behalf of M.
DK does
On behalf of M.
And, so the method is that under the column for the current that's study for the next year. Or that
PAN card में 30 second hold.
according to this price that
Service will not. Service will 30 second.
there's
This matter may come up for hearing, my lord.
heading
My lord. There is no problem.
order.
On the short date, my lord. Of course. Date. Much of it.
Your lordship. The last occasion also, your lordship may peruse the last order. The last occasion also, it was listed the same column. And since it is an appeal against dismissal, so there is no scope of mediation. Accordingly, court have fixed today for, we fixed for hearing. Again, it has been listed in that column.
You are appearing for respondent number 2.
You draw it. Yeah. The author pointed out that referring to the order of the court is that on that day also the and there was that forget but again the is the matter under the table. According to it, permitted that the matter on
May I please your lordship? Kumari Dolo is the only surviving legal heir. There is no other legal heir and he is aged lady. If it is possible, your lordship. Oblige, your lord.
May I please be my lord? Lordship, as per office note dated 4/8/25, lordship. Answer postal receipt is for respondent number 3 return. Responsible is the driver of the vehicle, so he may kindly be stuck of because it is for enhancement of compensation only. So 1, 2 already served, 1 already appeared.
artists are here ago the current for the appellant. Notice upon respondent number 1 and for
1 and 2 served.
2
1 appeared, 2 appeared, filing वगैरह नाम लord.
have already been served, but they are represented. So Agoda further that the number 3 is the owner of the vehicle,
Driver of the vehicle.
driver of the vehicle.
This is for enhancement of compensation.
Appeal has been called for enhancement of the quantum. And as such, the next responsible party in track of the area of the appeal. We are taking to the subject the Agoda part by appellant. Take up the number of appeal at the cost of the appellant.
Reminder for LCR may kindly be.
Dated 4/8/2025, which that LCR has not yet been received. It provided that it matter to the garden driver for transmitting the report
May kindly be
released after
picked for hearing after receipt of LCR. For
the matter for get or receipt of the LCR. The garden
much.
May please, Your Lordship. Lordship, as per office note dated 4/8/25, Lordship, response number 1 has already appeared.
IA is listed there.
Yes, your lordship, it is a stay vacating, a stay application. No order has been passed. So my prayer is that
Take
they
steps,
may
because
be
it is
directed.
listed in the.
Already the appeal has been admitted.
Or number.
Question number 1.
Or one. Interlocutory application or the appellant mistake that or or in the or one come by or that that or that
No, Lordship, response number 2 and 3 service is not complete.
when
And they will be required, Lordship, because it is a case of pay and equal.
there is a development of state done award of the learned student of life. So part of the or something over the award state or or the part over the award state subject award 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 for it from today. In terms of I
Highly obliged.
So in the main appeal, Lordship, we may direct take steps.
sir, or not okay.
4/8/25. There is no mention about response number 2, Lordship. The 3 was out.
The response number 3 which is in mark out of 6. According to that, or not, they take best of part 3 as the support part 1.
Lordship, only usual process, Lordship, because last time we took by postal only. Last time we took steps only by postal. So this time we want to take steps by usual process.
Both the way.
Obliged.
This is the method.
Highly obliged, your lord.
Lordship, appeal is already admitted and my friend has appeared for the claimant. And Lordship, she has also filed a cross objection in this appeal. And cross objection will be heard at the time of hearing of the appeal. And Lordship, appeal has been admitted on 23/10/2024. And we have also filed an application for stay of the judgment. In this particular case, Lordship, this was a government employee and he died after notification issued by the government in 2017 that the family member will get the full salary. And Honorable Supreme Court has already clarified that they will entitle for the under the conventional head. So in this particular case, conventional head amount will be 2,18,000 plus interest. 2,28,000 plus interest.
Your lordship, my prayer will be conventional head plus future performance. At least for the time being, I am entitled for future prospect as well as conventional head.
Tribunal has not granted future prospect.
Constitutional head and
Future prospect, according to Shashi Sharma's judgment, three judges bench, I am in, according to that judgment, that case was of Haryana, not of Assam. But even though relying on that judgment, if I rely on that judgment also, I am entitled for future prospect as well as non-conventional case. So if that much is allowed to be withdrawn, then
Lordship, this court also clarified this matter in a different judgment. Today, I could not drop the judgment that claimant is entitled for only the conventional head.
regarding this court judgment, I have another submission. Division bench of this court has passed a judgment. So if any judgment passed by a single bench, subsequently, later on, it will become par imperium. Kanika Hazarika's judgment is, your lordship is well aware that the nexus between the accident and the
no, you produce the judgment.
Your lordship,
Consider this application time
lordship, then a short date may be given.
or the some certain also hard. It's the matter of
Yes.
further consideration.
Your lordship, apart from this, there are two Supreme Court judgments. While dealing with the money decree, the law says that they have to deposit the entire amount or security. And for granting stay, it is a condition precedent. I have put the judgment, but
Okay.
I will rely on that.
Before the court.
Highly obliged.
May please give me the lordship, this appeal is settled between the insurance company and the claimant lordship on additional sum of rupees 4,75,000. And we file this.
This
petition.
I is for
Yes, sir. For settlement.
compromise.
Yes.
The award was for 10,31,000 for us.
Yes, lordship.
Thereafter, you have settled the
4,75,000. Additional amount of rupees 4,75,000.
in addition to this amount.
Yes.
In addition.
Yes.
That is already paid, lordship. Only if additional amount is mentioned, that
There was a direction for keeping the amount in fixed deposit. That has been done.
that has been done. Lordship.
Are you sure?
Yes, Lord.
So now this should be paid to the claimant number 1, lordship. This additional settlement in the bank account of the claimant number 1, lordship.
Number
1. Petitioner number 1, lordship, in the bank account, will furnish the bank account details to the insurance company. They will deposit.
other claims are consent other.
Transfer.
Yes, Lord.
Third, Mr. Agora, third for the epic and also third.
And Dr. Lordship.
And then also third. This application, this joint application, departs the payment. The extra payment under the MSc Appeal number 529 of 2017. Allow the petitioners to make compromise settlement that the additional amount being 4,75,000. May be allowed to be deposited in the bank account of the account bank account through electronic media transfer or electronic transfer. It's submitted in the bar that the appeal number 5, MSc Appeal number 5/9/2017 has been referred for enhancement. Case number
1761,
1761 of
2014.
2014. And original amount, original amount for a thing as paid
No,
Yeah.
Lordship, along with the interest.
along with the
Interest.
and both the parties have settled the appeal for enhancement that is 4,75,000 and the state amount will be deposited by the insurance company in a period of 4 weeks from today for the account of the claimant number. And therefore, it is considered to allow this application for the private number MSc Appeal number 5. Both the parties are and it appears that the party has settled the claim amount that is additional claim that to be 4,75,000. But according to this, application is allowed MSc Appeal to extend the disposal. The insurance company is holding the amount of additional amount of 4,500 account of the appellant's claimant number 1 by electronic within a period of 4 months.
Obliged, much obliged.
The return the record of the Lord and private.
Lordship, this is also same Lordship. The settled amount is 2 lakhs, Lord. Additional 2 lakhs.
2 lakh.
Additional 2 lakhs.
Already awarded amount paid, sir.
Paid.
Yes, Lord.
10,03,000.
And this will be also paid to the claimant number 1 in the bank account. 14 also same Lordship. The 2,20,000 Lordship.
2,20,000. Initial award amount along with the interest that we have already paid. We settled as 2 lakhs 20, enhanced amount of 2 lakhs 20. Additional amount.
Here only one claimant, Lordship. So claimant number one, Lordship.
Only one claim, injury case. Yeah, injury case.
Okay.
Lordship,
Respond number 3, Lord.
Lordship, I have a prayer. We will be depositing under 4 weeks, but that 4 weeks will count from the date he gives the bank details. If he is late in giving the bank details, we will be not be able to.
Lordship, no problem. I'll get that. Within 4 weeks, that will be.
Agorota, Lord, claimant. That part is the bank part.
Yes, Lord.
Sir,
In the all the cases, Lord. All the cases.
well,
Other cases also will furnish the bank details. Within 4 weeks.
within 4 weeks, if they filing in the last day, then
Within 1 week, yes, Lord. Much better.
Numbers 33 and 34.
Lordship fix these cases for hearing, Lordship, in the month of September. They are already fixed for hearing only, Lordship. And on the last occasion,
Sir, Sorma, Lord, sir,
on behalf of M. Hussain.
what is your name?
R.I. Mandal.
RN?
R.I. Mandal.
RI Mandal,
On behalf of
Deputy Officer.
on R. M. Hussain. On behalf of M. Hussain. And the respondent number.
both the appeals are tagged, Lordship, one preferred by the insurance company and the other preferred by the claimant.
34 Lordship, I am the 33, I am the respondent.
Okay. Though the matter is under the cover, is succeed in the part that no purpose is served by the person of the petition. And the hearing. Hearing. Effective for 5. Other appeal service.
I am the appellant in item number 33, Lordship. 34 is preferred by the claimant. In 33, Lordship, service is complete and LC has also been received. It is ready for hearing, Lordship.
No, we have already passed the order for hearing. But in this matter,
34 I am not aware.
34, I am the petitioner.
Go for the appellant. So you have to take still upon respondent number 3 and 5.
But 1, 2 Lordship.
Number 3 has been struck off.
Also, respond number in our appeal, respond number 4 was struck off.
You go for respondent number.
Lordship, in their appeal, I am for respondent number 1, Lordship. Last occasion, if Lordship used the order, Lordship, we took instruction to appear in their appeal.
Respondent number 1.
Respondent number 1, Lordship.
So you have obtained inspection.
Yes, Lord.
IPA.
Yes.
RI Mandal on behalf of MSC.
Notice upon respondent number 2. And respondent number 3. Start of the area of this appeal. As such, start. Here and also with this.
Yes.
This method for getting along with them. But one of on
Obliged.
Item 35.
May it please your lordship. I think my learned friend has objection if it is referred to mediation.
My lord, they have raised the issue on the genuineness of the voucher, lordship. Amounting to be, yes, lordship. My lord, in fact, it is a case of 2017. Matter was registered in the year 2020.
So the method is but the purpose are different. Yeah. Or
On 25th September.
Much of it.
Items for admission. Item
My lord, as your lordship directed, I have filed the affidavit relating to the payment of rent being made by me from day to day. And all along, I have been paying the rent. And the land was, the date is also, we have got the date of the notification whereby the land was acquired by the government on 28/5/2025 night. And they are now from 28/5/2025, the government has become the owner of the land, my lord. And the respondent is
after that is after
notification. After notification, my lord.
no, after pronouncement of the judgment taken by the third village.
Yes, ma'am.
Yes.
From that date till today, we are paying the rent. And your lordship may kindly see what more they are entitled as per the law. They are only entitled for the rent. We are paying the rent. And now they are no more owner.
My lord,
Just 1 minute, your lordship may kindly. This is very important judgment for the. I have highlighted, my lord, the paragraph 8. At the outset, we may point out that there are different methods of valuation, namely income profit method, cost of construction method, rent method, and contractors method. In the present case, the just one.
No, it is revision which they are testing the correctness and otherwise of the accused judgment. We are not concerned with the subsequent development.
In revision, your lordship may take. I have in revision case, your lordship may take the subsequent events also.
How?
It is permissible. I have the some law is there. Case law is there.
You produce it?
Yes, I will produce, my lord.
When?
I have gone through.
You produce it right now?
Right now, it is not. But I have gone through some judgments.
whereby it is permitted for the revisional court to take subsequent events and facts while exercising the judicial revisional jurisdiction. Just your lordship may kindly see this. Just I am reading, my lord. At the outset, we may point out that there are different methods of valuation, namely income profit method, cost of construction method, rent method, and contractors method. In the present case, the arbitrator has applied the income profit method. The above two issues are interconnected, as the arbitrator has assessed damages on the assumption that after 10/3/1987, the occupation and possession of the property was wrongful and illegal and in the nature of trespass. Accordingly, he has assessed damages on the footing that the respondent was entitled to mense property profit. This assumption was wrong, as the appellant was given time by this court to remain in possession up to 31/3/1993. In law of damages and compensation by Kameshwara so and so, the learned author states that right to mense property profits presupposes a wrong, whereas a right to rent proceed on the basis that there is a contract. But there is an intermediate, this is important, my lord, but there is an intermediate class of cases in which the possession, though not wrongful in the beginning, assumes a wrongful character when it is unauthorized, retained, and in such a case, the owner is not entitled to mense profit, but only the fair rent. In the present case, here, in their case, my lord, they are saying that lease period expired and we are occupying unauthorizedly. So this is applicable fair rent we are paying, my lord. And now subsequent development has taken place. The government has become the owner of the property by the operation of law. So when they are no more owner, my lord, then these subsequent events, your lordship may consider. And all along, they are also utilizing the money. They are withdrawing also, my lord. So when the foundation is removed, they are no more owner, then the superstructure will bound to fall. This is the law. When the basis of the proceeding has gone, my lord, then the all proceeding will go. And both the parties have challenged the appellant judgment, my lord. So when both the parties is challenging a judgment, my lord, then it will go, my lord. There is no scope for adjudication, my lord. And they are only, my lord, they are only the judgment.
What basis you are submitting this way?
My lord, earlier affidavit, your lordship may kindly see. I filed the earlier affidavit. I have quoted on 28/7/2025. Paragraph 4, my lord. Paragraph 2, page 2, paragraph 4, my lord. I have quoted the relevant portion of the Assam Land Requisition Act, where a notice as aforesaid is published. Page 2, my lord. Page 2, my lord. Where a notice as aforesaid is published in the official gazette. The requisition land and premises shall on and from the beginning of day on which the notice is so published vest absolutely in the state government free from all encumbrances, and the period of requisition of such land shall end. The provisions of this act on such vesting, the provisions of Land Acquisition Act with the rules framed thereunder shall so far as may be applied to such land. So another proceeding has started. Now your lordship knows it is well settled law, two parallel proceeding cannot go. Whatever his grievances is there, he can approach the
When the notice notification was published,
28/5/2025.
and the dictate was prior to that.
Prior to that, but now the honor, it is continuation, revision in continuation of the initial proceeding. Proceeding is still continuing. Now proceeding is going to be seized because of the operation of law. Two parallel proceeding cannot go, my lord. And here another thing, your lordship may kindly come to page 4, my lord. I have quoted the law. This is the law point, my lord. This is the subsequent events has come into play. This is the law, my lord. That it is respectfully submitted at the Honorable Supreme Court in the case so and so. Observed as follows. In Badrinath versus Government of Tamil Nadu, AIR 2000, Supreme Court so and so. This court observed that once the basis of a proceeding is gone, all the consequential actions, orders will fall to the ground automatically. And this principle of consequential order, which is applicable to judicial, this is very important, and quasi-judicial proceeding is equally applicable. Page 4, my lord, my affidavit. Just I have referred the affidavit, my lord. Page 4, my lord.
Yes. Paragraph number.
Paragraph 7, my lord. That it is respectfully submitted that the Honorable Supreme Court in the case so and so, Chairman cum Managing Director, Coal India Limited versus so and so. In paragraph 32, observe as follows. 31. In Badrinath, Government of Tamil Nadu, AIR 2000, Supreme Court 3243. This court observed that once the basis of a proceeding is gone, all consequential actions, orders will fall to the ground automatically. And this principle of consequential order, which is applicable to judicial and quasi-judicial proceeding, is equally applicable to administrative orders also. See also the state of Kerala versus so and so. So, now for example, your lordship may see, somebody has challenged the transfer order. In the meantime, his service is terminated. Whether pendency of transfer petition will be survived. Similarly here, he has claimed all along being a owner. Undisputed, he was the owner. How long? Till 28/5/2025. Thereafter, by operation of law, not the other thing, by operation of law, he is ceased to be the owner. So how can he continue this proceeding, my lord? Even though earlier judgment and decree was passed, this is the continuation of the initial proceeding, my lord.
Yeah, sir, down.
My lord, I have already made my submissions in detail the other day regarding this.
Regarding this,
This
law.
judgment, my lord, just now my learned friend has checked, my lord. This relates to my lord service law. My learned friend just now gave a very tactful example that if a transfer order is challenged and subsequently the service comes to end, then the transfer also goes. What if some pays were payable to, some dues were payable by the employee? Just because he has retired, will the pays will also be forfeited? Certainly not. It will be a counter argument against his logic, my lord. He is trying to equate transfer with some other eventuality. Here is a situation, my lord. He was found to be defaulter in payment of monthly rent from April 2010 onwards. And once he has been adjudicated to be a defaulter, he is no more entitled to remain back in the premises. On top of it, it was a case before the trial court, and on the basis of pleadings and supportive documents, that he was paying rent which was not proportionate to the market rate. So from the date of unauthorized occupation of the tenanted premises, the plaintiff is legally entitled. These are all settled principles of law. The plaintiff is entitled to recover compensation on top of the rent, because rent was not commensurating with the market rate. If he wants to show today that the market rent was of the market, then he ought to have laid evidence that during the trial court, my lord. This is too late in the day to argue all these things. In the trial court, they could not produce any evidence. It was prima facie established that they were defaulters. Once they are defaulter, their authorization, the Rent Control Act comes into play. By virtue of the
provisions of the Rent Control Act, he is illegally occupying the premises after being a defaulter. So he has to pay, there are two components, my lord. One is the defaulted rent, that is for 2 months only. 1 lakh which he has indicated, that is, I have checked from the pleadings, my lord. In the plaint, it is clearly averred that it is for 2 months, April and May, July, I think.
2010.
My lord, for 2 months, and that is the exact rent which has been given by the trial court. There is nothing infirmity in there. Second component is the compensation part, my lord. That after the reading of evidence, it was shown to the learned trial court that the rent which he is paying, he is not revising the rent. He is paying a rent which is lesser than the market rate. That is why the compensation element came. Now, at the end of the day, if he comes to say that property has gone to the government now, that is why he will not pay the compensation part. He will not pay the rent. This cannot hold good, my lord. Monthly rent, supposedly, my lord, today I am a tenant, I am occupying a shop in Fancy Bazaar and I am paying the landlord only 1,000 rupees. And in a suit, it is decided that against me that there is, it is inadequate, rent is not adequate. I have to pay compensation for my extended occupation of that particular shop. And tomorrow, if the shop is taken by government, can all my liabilities be set aside like this, my lord? He wants to escape from paying his liability.
My lord,
Judgment is very much executable. It's an executable decree, my lord. By his arguments, he wants to make it infructuous, my lord. It's a paper, sort of a paper decree. It cannot be allowed, my lord. That too in this revisional stage.
now, my lord, one reply I would like to give, my lord. The learned court below has fixed 2,000 per day. On what basis, my lord? No basis. The appellant court has reduced it to 500 per day, despite payment of the rent, my lord. And what is the method, my lord? This judgment is clear, my lord, which I have
My lord,
already referred.
arbitration,
Let me
he is showing a judgment of the arbitrator, my lord. The arbitrator does not have any role to play in rent control matters.
This is
Law is settled.
law
Rent
in
control
lease.
is under a special legislation which is Urban Area Rent Control Act.
My learned brother is wrong. In lease, the arbitration is permissible.
My lord, this is a proceeding. He is blowing hot and cold again. And in one moment, he says, I am depositing rent in court. That means you are admitting that the issues are governed by the Assam Urban Area Rent Control Act. In another breath, he is saying, no, it's a lease deed. We are governed by the Transfer of Property Act. He is, my lord, blowing hot and cold at the same time.
Just, my lord, he is responsible for making the lease. Now, what is the lease, my lord? Just I am coming, my lord, the heading of that.
My lord, insofar as that scaling down of the compensation to 500 rupees is concerned, my lord.
Yes.
On a very limited, my lord, scope, only to that part, my lord, I have preferred the second revision, my lord. Grounds I have taken, which I have taken, confines to only that aspect that when the appellate court brought down the compensation from 2,000 to 500 rupees, it did not record any reasons. And my submissions, my lord, if your lordship peruses the appellate court's judgment just for a moment, my lord, just one piece.
Mr. Rahul, on the other day, you have
Lordship?
on the other day, you have argued on this point.
Second revision, only one moment, my lord, only one. Second, I will take just 1 minute time, my lord. Second revision, I did not argue, my lord, but I had covered that point. It is true, my lord, because I want to place a judgment, my lord. If your lordship comes to page 70,
Other,
I think lordship will,
revision.
yeah, other revision, my lord. Page 74. Page 74, my lord. The relevant paragraph starts from page 73. I'm just once I'm reading it up. Appeal is dismissed on contest with cause. That means it has gone in my client's favor. From the findings of the issues which are upheld by this court, I am of the view that the respondent plaintiff is entitled to recover the area rent of rupees 1,25,592 from the appellant.
and the appellants, their agents are liable to be evicted from the suit premises by following due process of law. And the respondent is also entitled to get compensation from the appellant for the unauthorized stay in the suit premises after so and so at 500 rupees per day till realization of decree amount instead of 2000 rupees per day, as the same is higher in degree. Now, my lord, in my respectful submission, when the honorable court has scaled it down to 500 rupees, my lord, it should be backed by some reason. Why the honorable court finds the 2000 rupees arbitrary, my lord, or unreasonable? Nothing has been recorded in the entire judgment. There is no whisper. That is why my lord, I am harping upon a or decision of the honorable apex court, my lord. I am just placing it for your lordship. My lord, state of Uttaransal and another versus Sunil Kumar Vyas and other. Lord, if your lordship comes to page number paragraph 18, my lord.
Yes.
Page 676. Page 676, paragraph 18. Only one paragraph I will place. May I read, my lord? Judicial determination has to be seen as an outcome of a reasoned process of adjudication initiated and documented by a party based mainly on the events which has appeared in the past. Court's clear reasoning and analysis are basic requirements of a judicial determination when parties demand it so that they can administer justice justly and correctly in relation to the findings on law and facts. Judicial decision must be perceived by the parties and by the society at large as being the result of a correct and proper application of the legal rules, proper valuation of the evidence adduced, and application of the legal procedure. The parties should be convinced that their case has been properly considered and decided. Judicial decision must in principle be reasoned, and the quality of a judicial decision depends principally on the quality of its reasoning. So here, my lord, there is no reason, my lord, why it has been brought down to 500. That is my only grievance, my lord. Rest I place it before your lordship disposal, my lord. But I am just taking shelter under this law, my lord.
Okay.
My lord, just 1 minute, my lord. Your lordship may kindly come to page 29 of my petition, my lord. No basis for arriving at the compensation by learned trial court as well as by appellate court. And your lordship may kindly come to page 29, my lord. It is the document of the respondent, landlord. What my learned brother is submitting is different thing. It is clearly written by lord. Agreement of lease. And now your lordship may kindly come to page 34, paragraph 7 of this lease document. There is a clause for referring the arbitration. He has met and he is denying. Now both the parties proceeded as if it is a tenancy agreement. So this is the mistake of fact. Mistake of fact is wide as per the Indian Contract Act. So entire proceeding will go. And just I referred that judgment, your lordship. In same paragraph, Honorable Supreme Court says how to arrive at the fair end, how to arrive at the compensation. Just after a highlighted portion, your lordship may kindly see. Even after a highlighted portion, my lord. Even assuming for sale of arguments, for sake of argument that the arbitrator was right in applying the income profit method, the arbitrator has erred in not taking account the expenses which the appellant was required to bear for maintenance of the property, including payment of taxes. The said property was under requisition up to 10/3/1987. The fair rent of the property was rupees so and so, which was accepted by the respondent up to so and so, which fact has not been considered by the arbitrator. In the municipal record, the value of the building is in dilapidated condition, was shown as rupees so and so, which was 10% of the original cost, which fact has also not been taken into account by the arbitrator. Similarly, there was no reason for the arbitrator to assess the damage for open larger space at the rate of 10 per square feet month, when these open spaces from part of the main building for which damages were assessed per month. The respondent did not submit the valuation report in support of its claim for damages. No valuer is examined on behalf of the respondent claimant. In the present case, buildings were old and their age has not been taken into account by the arbitrator, particularly when the said property is sought to be compared with the property situated at so and so Daryaganj, New Delhi. No sale instances have been put in evidence. The evidence of the three eyewitnesses who were examined on behalf of the respondent was not cogent and reliable for the purpose of assessing the damage. These three witnesses were laymen and they were not expert on valuation. The arbitrator has not taken into account the discounting factors such as the age of the building, dilapidated condition of the building, of the flats, expenses to upgrade the building, etc. There is no evidence of support the rate of 15 per square feet per month for the build up area. There is no reason as to why the carpet area and not the built up area has been taken into account. The point which would like to emphasize is that large number of relevant factors have not been taken into account by the arbitrator while awarding the damages to the extent of rupees so and so. Before us, it was so, and no evidence is produced by the respondent before the learned court. Learned court has, without any basis, fixed it 2,000 per day, which is not permissible, my lord.
Okay, then started for the for content. Argument concluded, judgment reserved.
And my lord, today we have filed one affidavit. It has perhaps not come.
Yes.
It has come. It has come. Your lordship may kindly take the date, my lord.
We'll say we have received it.
Yes, yes. Then it is there, my lord. Much obliged.
Deeply obliged.
Attend for hearing under 41, item number 36.
I have concluded my part, my lord. He is to reply.
According to you, take a substantial question number 1 in the memo of appeal.
Yes, ma'am.
And the additional
Yes.
substantial question of law number 1
One.
are required to be paid. Yes, sir. Ahmed.
My lord.
Yesterday you have submitted that you will produce one judgment.
Yes, I. Loss of kindly see first, 2015 to SCC 682.
What is the relevant paragraph?
Relevant paragraph, my lord.
Page number, Himan? Page number? 15 to?
Page number?
Yes, the judgment page number, my lord. 2015 to SCC 682. It is paragraph from, my lord, 9.6 to 16. 9.6 to 16. The Lordship kindly see paragraph 9.5 first. 9.5. The details of so the effect this kind of point 9. On plain reading of the above said provision, it is quite implied that a counterclaim prepared by defendant in a suit is in the nature of a cross suit and by a statutory command, even if its suit is dismissed, counterclaim shall remain alive for its duration. For making a counterclaim entertainable by the court, the defendant is required to pay the requisite court fee on the valuation of the counterclaim. The plaintiff is obliged to file a written statement in the case there the default, the court can pronounce the judgment against the plaintiff in relation to the counterclaim put forth by the defendant as it has an independent status. The purpose of scheme relating to counterclaim is to avoid multiplicity of the proceeding. When a counterclaim is dismissed, one being executed on merit
it is for forceless versus the rights of the defendant. As per Rule 6A2 of the court, is required to pronounce a final judgment in the same suit, both on original claim and also on the counterclaim. The seminal purpose is to avoid piecemeal adjudication. The plaintiff can file an application for exclusion of the counterclaim and can also do so. At any time before issue are settled in relation to the counterclaim, we are not concerned with the such a situation. Now, illogically see 10. In the instance case, the counterclaim has been dismissed finally by expressing on opinion that it is barred by principle of order to rule to CBC. The question is, what stress is to be given to such an expression of opinion? In this context, we may refer with the profit of definition of term dictee as contentious. Now, 12. From the aforesaid enunciation law, it is manifest that when there is a conclusive determination of right of parties upon adjudication, the said decision in entertained circumstances can have the status of a degree. In the instance case, as has been narrated earlier, the counterclaim has been executed and decided on merit, holding that it is barred by principle of so. The claim of the defendant has been negated in Judge Mohan Swenso. Now just to kindly see paragraph 14. I didn't know important, my lord. 14, my lord. In this context, we mainly faithfully refer to a three-judge bench decision on Ramchand Swenso, wherein their lordships were dealing with what constitutes a final order to be a decree. The thrust of the controversy herein was that whether an order passed by the executive court setting aside an action cell as a nullity is in the appeal order or not. The court referred in Swenso, in deciding question whether order is a final order determining the right of parties and therefore falling within the definition of the section 2 and 2, it would often become necessary to view it from the point of view of both the parties in the present case, the judgment debitor and the action purchaser. So far as the defendant debitor is concerned, the order obviously does not finally decide his rights in a press release order. The position, however, of the action purchaser is different. When the action purchaser is declared to be an highest bidder and the action is declared to have been concluded and in right accrued to him and that became entitled to conveyance of the property, though the court on his paying the balance unless the sale is not confirmed by the court. Where an application is made to set aside the action sale as a nullity, if the court set it aside either by an order on such application or suo motu, the only question arises in such a case in between him and the judgment debitor is whether the action was a nullity by reason of any violation of order 21 of the similar mandatory provision. If the court set aside the action sale, there is an end of the matter and no further question remains to be decided so far as he had an judgment debitor are concerned. Even though a resale of such case is ordered, as an order cannot be said to be an interlocutory order, as the entire matter is finally disposed of. It does manifest that the order setting aside the action sale amount to final decision relating to the rights of the parties in dispute in that particular civil proceeding, such a proceeding being one in which the right and liabilities of the parties arising from the action sale are in dispute and when they are finally, yes, the parties in such a case are only the judgment debitor and the action purchaser. The only issue between them for determination being whether the action sale is liable to be set aside. There is an end of that matter, and when the court passes the order and that order is final, as it finally determines the rights and liberties of the parties, the judgment debitor and the action purchaser in regard to that sale, as after that order, nothing remains to be determined as between them. After stating the court role that the order in question was a final order determining the right of the parties and therefore held within the definition of degree under section 22, read with section of which was available order. Now, 16. We have referred to the aforesaid decision to highlight that there may be situation where an order can be status of a degree. A court may draw up a formal degree or manner, but if by virtue of the order of the court, the rights have finally been executed, irrefutably, it would assume the status of a degree. As is evincible in the case at hand, the counterclaim which is in the nature of a cross suit has been dismissed. Nothing else survives for the defendant who had filed the counterclaim. Therefore, we have no hesitation in holding that the order passed by the landed trial judge has the status of a degree and challenge to the same has to be made before the appropriate forum where appeal could lie by paying the requisite fee. It would not have been unsettled by the High Court in exercise of power under Article 227 of the Constitution of India. Agree, the order passed by the High Court is indivisible. Consequently, the appeal is allowed and the order passed the this is the finding. Now, in the present case, my lord, a composite appeal has been filed. No appeal filed against the dismissal of the counterclaim. This is the now on the basis of that judgment, the Himachal Pradesh High Court has clearly discussed. The second case I remember, Saran versus Gulab Chan and other.
Petition की बात है।
नहीं तो है जरूर भाई
ऐसे आ रहे हैं
RSA number 358 of 2005.
हिमाचल
My philosophically, details has been discussed by my lord.
Did the proposition of law by this case that without challenging the order, it dismissing the counterclaim, they cannot challenge the order. So
No,
that
they-
doesn't the decree.
Yes,
But in the
no, they can challenge that also can be challenged, but since both the trial court has allowed appeal at the same time dismiss the counterclaim, he can challenge that order also, and particularly he should be challenged the order passing the counterclaim, because his case is that he claimed in the counterclaim that the sale deed executed on 5/1/1996
counterclaim was the present case, its counterclaim was dismissed.
dismissed. It means that he in counterclaim he sought a degree.
He has not preferred an appeal.
No, not appeal.
Yes.
He has not preferred appeal.
Appeal against the judgment and decree.
First in suit.
Yes.
First in suit. But
What is the bar?
he can challenge that. No bar.
Yeah.
But there is he can.
Yesterday you submitted before the court that
there is a bar.
No. I am not bar. But he should file separate appeal also. Separate appeal.
We cannot compel him to file an appeal.
That is why if he not filed, then he has no claim. He cannot come to the High Court. He cannot. That's.
Is it a proposition of law laid down in this?
Yes,
case?
it is. This is the also can you see title of the my lord. First page title my lord. The also can you see.
In which case?
Rojani, the title page is also can you see. The order 8 rule 6A, order 2 so and so, order of dismissal of counterclaim when constituted degree. It is a degree, my lord. Counterclaim when conclusively executed on merit and dismissed by order of court, finality is attached in respect of right of defendant. My lord,
Which judgment you are reading?
Rojani, 2015 to STC.
Okay.
First page, my lord, first page. Title basement. So, counterclaim when conclusively executed on merit, dismissed by order of court, finality is attached in respect of right of defendant.
No, that is the head.
As order,
Oh.
that is, it is a degree, my lord.
The head of. We should
Yes.
go with the head of.
Yes. Then that is why it is started from, my lord, paragraph 9 to 17, my lord. Clearly discussed, my lord. Paragraph 9 is clearly discussed what is the degree, how to constitute the degree. The order passed in the counterclaim is a degree.
No,
It should be
no
challenged.
doubt about it, that it is a degree. But the
Yes.
question is, where is the bar? That
No.
unless it challenge the order or degree passed in the counterclaim, cannot challenge the.
No, I am not on that. He can challenge the order passed in the suit. No bar. But he is to substitute his claim because his claim has been defeated.
No,
His,
that's
his,
right.
his claim, my lord.
Unless we admit the appeal, how can we decide that?
Now, my lord, another point is, my lord, when the appeal is filed without filing the appeal against the counterclaim, this honorable court may not entertain the appeal, may not take up the question. I give the judgment. Another, the Lordship Kaliji, second judgment, Saran versus Gulabkhan, Himachal Pradesh, my lord. Here, paragraph number is, because it is obtained from online, paragraph number is not in order, but the Lordship kindly says just finding page, my lord, last page, 24th. All the judgment that Rajini Singh and other Zohar Singh, all this has been discussed, and finally he concluded. Paragraph 24, last page of that judgment. Because the High Court not entertained the appeal. Consequently, in view of the detailed discussion made here in above, this court is of the view that learned first appellate court erred in entertaining the composite appeal. This is a composite, that was a composite appeal. Having been prepared on behalf of the defendant, lying therein challenge to the judgment and decree passed by the learned trial court as well as rejection of their counterclaim. Who could have filed separate appeal, affixing separate court fee, laying therein specific challenge for rejection of their counterclaim. In view of the aforesaid discussion as well as law laid down by the Honorable Appellate Court in Rajani, additional substitution question of law is answered accordingly. In view of the finding returned by this court for additional substitution question of law, other substitution question of law formulated at the time of admission need not be answered at this stage. Hence, the appeal shall allow and the judgment dismissed. Because he's to file two appeal by the court fee. Then, if in that case, law has a substantial question of law has been formulated. The Lordship kindly see paragraph 13, page 6, in the last page 6.
Of
that case. Of that case. Himachal Pradesh. Down below page number 6. That is why the Honorable Himachal Pradesh High Court formulated the question of paragraph 13. This court, taking note of above said submission having been made by the learned counsel for the appellate court, as well as laid down by the Honorable Appellate Court in Rajani so deems it proper to frame the following additional substantial question of law for proper adjudication of the controversy at hand. Whether The learned first appellate court has erred in entertaining the composite appeal, having been preferred by the defendant against the judgment and decree passed by the learned trial court, decreeing the suit of plaintiff and dismissing the counterclaim preferred by the defendant. That too, without affixing separate requisite could be as per counterclaim is concerned. So on that, first your lordship may take up that decision, whether it is correct. Then my lord, other question may come. Is it? Now, your lordship Kalisi, your lordship, I remember that if while I arguing case before lordship, your lordship give one judgment to grant for it. I have gone through that judgment. That concurrent finding of both the court below cannot be interpreted. That judgment, my lord, I give on the pass of judgment. It is Supreme Court, my lord, the Gurudev Kaur and others. Gurudev Kaur.
Attention to
Attention to appeal number 2083 of 2006.
2006.
Details discussion is there, my lord. Yeah, paragraph from paragraph 52 clearly discussed, my lord. Even the first appellate court has committed some wrong, then that also could not be interfered. While both the concurrent findings are there. Second paragraph 52 to 50.
But even then court can interfere with the state. If there is perversity, finding the appellate court and
Yes.
the trial.
Yes. Yes, that is. And that point, I also referred to judgment before lawsuit on that point. Even this court has taken a view. It can reappreciate evidence on record if there is a perversity, my lord. Then, and that case also I am not. Jonathan. You lordship had decided on matter on Jonadas.
That the judgments are available.
Available is not there. I will look. But you lordship, this is my appeal. But other ground also there for dismissal. But main point I prefer two judgment regarding that the event perversity is there. If there is then reasonable would not entertain. I will give that judgment. So my lord, the thing is this, my lord. He should have filed a separate bill along with that. Should have, because suppose, my lord, a counterclaim, his claim is dismissed. How can he now say that that shall it is without making any appeal, my lord? He should, but that has not done. In my case, he filed. In my case, but his case himself he has not selected. Because counterclaim is a suit, and order passed is a degree. So that is to be examined by lawsuit. That is to be. Oh, it is here, man.
Okay.
It is here.
Give it to the court. But Mr. Ahmed, to decide that issue, we have to admit the appeal.
I have no objection.
As for that decision, I have given
My
to
lord,
you.
that point only that.
So, the
Yes,
meeting
composite will.
go in.
Yes, composite will. That issue is to be decided first, then my lord. I have no objection, but I pointed out.
As per the judgment of the Honorable Court, if he can file additional for fee in this composite appeal, then we can entertain.
No, now matter has gone. He has missed the bus, my lord. That issue is not there also.
Is there any bar in furnishing this court fee subsequent?
No, my lord, question is, my lord, composite appeal cannot, my lord. He should file separate appeal. In many cases, I now find that several cases has been filed.
The observation made by the Himachal Pradesh High Court.
No, in Himachal Pradesh High Court dismissed because the Honorable Court has additional district has committed wrong in this is in the composite appeal. This is the finding of the Himachal Pradesh High Court. He dismissed the appeal on that point. And other point is not placed. Only that ground appeal was dismissed.
Yes, the data.
If the law facts are so intertwined that if the facts are such that the counterclaim is not separable from the suit, then one can argue that without challenging the judgment in the counterclaim, I cannot challenge the judgment in the.
I am not on that. He
Here,
can challenge
because
he can challenge this.
yesterday he had said it is a bar.
Like yesterday's and today's.
So now my case is
Yesterday I am not actually I am not said that there is a bar. There is a bar, my lord, in if he is not able the motion before the trial appellate court could not take a play in here. This is my case. And this court is taken the point that since the counterclaim final disposal and it is a degree, he should make a challenge.
There is no dispute in the proposition. It is a degree. I may not challenge it. Now, if I succeed in my appeal and his suit is dismissed, my lord, matter ends there. I may not succeed. We are at the stage of admission, man. If I succeed in my appeal and the suit is ultimately dismissed either on the ground of limitation or on the second point which I have raised, my lord, then I am through, my lord. I need not challenge, assail the counterclaim.
Otherwise, my lord, instead my learned friend has stated the judgment that was relied by the appellate court, feeling that the moment, suppose I appoint one attorney long back, subsequently that particular I sell. Moment I sell this, myself I sell, executive sell it, attorney go. No claim, my lord. That attorney is not survive.
That is what
that is the law, my lord. That attorney will not survive because I am the principal.
The principal may
I am the principal. I will sell the property after 10 years of execution of power of attorney. Thereafter, after 10 years, I sell this property. In between 10 years, he has nothing to. I sell the property. Automatically, attorney has been ceased to exist.
That is the crux, man. Automatically
exist.
I give an example, man.
Because my lord,
if my learned friend permits me,
no.
I have given a power of attorney to Mr. X. That power of attorney will not debar me from entering into a sale agreement. Lordship will kindly contemplate a situation. I have given Mr. A gives the power of attorney to X. Independent of that, my lord, A enters into a sale agreement. X is not informed. X also enters into a sale agreement. What will happen? It will only give rise to multiplicity of proceedings. A has every right. The Supreme Court says that A is not bound by, because he has given the power of attorney, it is not that A has to take permission from the attorney holder before entering it, but A has to inform him. That is what the apex court has held, that communication is necessary. The moment it is established that the communication has been made, then the principal can go ahead. Then it will be automatically terminated. That is my respectful submission.
My lord, during the period of success of the attorney, yes, if before execution of my sale deed, if my attorney will execute, then I will bound. I must follow the that sale, my lord. But since he has not do anything, and as a principal I sell it to someone, then automatically it has been husband and he is my brother. We reside in same compound, my lord. He have the full knowledge. And after even 96,
Merely because he is brother, that means that he has that knowledge.
Natural evidence, will say evidence.
That is why
in evidence,
we are not hearing the appeal,
in evidence, my lord, in evidence I found in evidence how that question is they are not properly addressed.
Let the record.
Let my lord, if lordship admittable, let first that subsequent questionable that will be decided. If it will survive, then others subsequent question is to be formulated. Next, any that may be fixed, my lord, for issuing that subsequent question that will be decided. And thereafter, if necessary,
Substantial question of law has to be decided after admission of the appeal.
it is.
Then it has to be admitted first. my lord.
That is why I played before this court. This matter fixed.
The execution case.
Execution case, file one, I need. Not file.
Not file.
Let status quo be maintained, my lord. Let status quo. Let status quo. That is my respectful submission, my lord.
And he will, if the execution is filed, then he file IA, no problem.
No, IA is there, my lord. I have already
Then
filed.
it will be taken up when the file, my lord.
Execution case file.
No, if file he mentioned, then it is not passing order. Yeah, this is it will be heard. It will be heard
The appeal
on
is
that
admitted.
following question of law immediately after.
We'll see. Examine the substantial question. Law
My lord,
suggested by him.
Yes.
My respectful submission, my lord, at least that status quo be maintained, my lord, in the IA. Because,
Will say.
my lord,
But the execution case has not yet been filed. There is no immediate chance of execution study.
that is there, my lord. That is there, but I'm only praying for status quo, my lord. If he says he is in possession, let him.
I have no objection. State matter, I have no, if the lawsuit admit appeal, automatically it will be stayed. If the execution started, they will make mention. I have no objection. But lawsuit may decide that point, my lord. Hello.
Wait, please, your lordship. My lord, the impute judgment, my lord, is at page number 62. And the first judgment that is in this passed in the suit that starts at 52. If lordship allows me, my lord, I would like to start from this,
What?
my lord.
Where is
That have annex. That is at page 8, my lord.
But you have to mention this substantial question of law in the memo of appellate.
Right. My lord, this is also another format, my lord.
To go to subject of 3 to section 100.
Correct. 100. Section 100. My lord, in the memo of appeal, your lordship is correct in saying that section 100 subsection 2, that in the appeal, under this section, the memorandum of appeal shall precisely state the substantial question of law involved in it. My lord, we have mentioned the grounds of the appeal in the appeal memo.
You also go through this decision.
Correct.
Of the Supreme Court.
But this is Lordship may construe it as a part of the memo and appeal because it already.
We are not considering it till today.
Correct, my lord, but in my respectful submission, my lord, since it is attached to the memo of appeal, but there cannot be the appeal memo, there is no specific format that has been prescribed by the code. The judgment, if to my respect,
This is the format.
my lord, what my humble understanding.
The code itself.
Yes. It's true, my lord. We have stated the grounds on which we are urging before the second appellate court.
Then the problem is that till that I have not admitted any appeal.
My lord, correct. Yes.
Then if we accept you, then it will set a bad precedent.
Right.
So you file amended appeal by today itself.
Well.
Tomorrow we will take it up.
Well.
Third, tomorrow, learning. The PK does learning. This is the matter tomorrow. The meantime, file amended memo of appeal incorporating the other state substantial provision of law in the memo of appeal. Please the matter get to here.
I may pray, my lord. Instead of tomorrow, can it be on Monday, my lord? Tomorrow some problem is there on my part. Monday, my lord.
Monday is acting.
He has already that IA order is there, my lord. He can he can get the time. IA order is there, my lord.
Where?
Condemn the delay, my lord. And today's order that the honorable court would be taking up the RSA on Monday. The executing court, he can show that, my lord.
No, my lord, executing court may not, and because in earlier occasion also we have showed the order of in that proceeding.
Tomorrow I was praying.
Today's
Or tomorrow in the first half, if second half you have problem.
Mal.
First half?
Yes. Mal. First of Mal.
11 o'clock then.
Mal. We'll do it.
At 11 o'clock.
Yes. Obliged.
39. May I please lordship, my lord, in this case, in this appeal, my lord.
Appeal is already admitted. Appeal is already admitted.
Yes, my lord, but my lord, the interim prayer, my lord. And I is there, my lord. And I file one I, my lord, 2431. Praying for granting ex parte ad interim order.
Pardon?
Ex parte ad interim injunction, my lord. 2431. And since there is, my lord, view of emergent situation, my lord, and exigency to intervene by this moratorium. And since, my lord, the prima facie case, my lord, and relative convenience and irreparable loss is also in the favor of the appellant. So, my lord, considering all this
elements for granting, my lord, ex parte injunction order, my lord.
Where is that order? Order dated 1/8/2025.
Page, my lord, 19.
It's 19 of this IA.
My lord, 5/7/25. Order dated 5/7/25. 1/8, my lord, order dated 1/8. Certificate copy of the order second, my lord.
You have
Obtained.
received that copy.
Yes.
You are It is appeal is listed today for consideration of the IA.
Yes, my lord. For in the prayer for my lord, the interim injunction was not granted me. Just notice was issued on the appeal.
The next date is 6th of then what is the urgency?
My lord, my lord, the petitioners applicants have already been dispossessed by the respondents, my lord. They have cultivated, my lord, by our land, my lord. And since, my lord, if this honorable court not pass any order restricting them, my lord, then that will be, they will suffer irreparable loss, my lord, and damages.
But the position is not with you now, right now,
No, my lord, this has already been taken by them, my lord.
taken by them.
Yes, my lord.
Then where is your prima facie?
Some person only one machine is there, my lord, from outside me. Our conflict in the person in the
Where in which paragraph you have stated that the purpose?
paragraph 12, my lord, of my petition, appeal, my lord, appeal.
Read it.
My lord, let the appellants beg to state that in the present circumstances, the appellant as prima facie case, being the patta holder, the applicants have the case of infraction of their legal rights against the respondent number 1 to 5. As procedure, the applicant have title and possession of some portion of land. Thus, the balance of convenience is in favor of the appellants, and finally, if the respondents have the intention to cause disturbances to suit land, in that case, the appellants will suffer irreparable loss, which cannot be compensated in terms of money. Graphs, my lord, kindly see page, my lord. Page, my lord, 22, annexure A of appeal. 22 of, my lord, appeal, page 22. It's not have cultivated the, my lord, the maize cultivation, maize crops, my lord. And thereafter, my lord, disposes, my lord.
They are the appellant here.
Yes, my lord, appellant.
And next page.
Well, next page, my lord, that is, my lord, the deed of sale deed, my lord, on the sale deeds. Sale deeds and, my lord,
Page number.
page number 23 onwards, my lord.
Sale deed.
Yes, my lord. It's not evidence parsing the suit lines. Suit line, my and got their name mutated by the authority, my lord. Mutation order, kindly see, my lord, page at page 61. Right side, my lord. Chakra Vikhar, author.
Detail number 35, 36, 37, 38.
8, yes, ma'am.
They are the
Appellant.
appellant here.
Yes, yes, ma'am. They approached the authorities, my lord, for relief, my lord, but it was not considered by the authorities, my lord. Thereafter, they filed title suit, my lord. And along with title suit, my lord, they filed case number 36/25, praying for, my lord, in ex parte in the injection, which was not considered, my lord.
Now, which plot of land is in your possession? A, B, or C?
The disposition, kindly similar disposition by the respondents is also the photographs. My lord.
You have stated in your memo of appeal that some portion of land is within your possession. Which portion? Which city?
My lord, it is not clear, my lord. Not. No,
Then
I
why
have
should
not
I
taken the.
consider this prima facie case in your favor? It cannot substantiate to the court that some portion of land is within your possession. Cannot say that of the land.
I will take instruction, my lord, for it. I will have to take instruction for that. Because, my lord,
Okay, we'll consider it as last item. In the meantime, you obtain instruction.
yes, ma'am. Today, sir. Ma'am.
Today.
Yes, ma'am.
Item 40 and 41. I am certain I have some difficulty today, Your Honor, because I want the memo first, which is required here, and by the records are not available with me because the local council has expired, and to Canada because the records have come here. I would you like to give me indulgence to take copy from the registry of the memo first.
File an application before the rate.
And let it be come out on Tuesday, Your Honor.
Active.
They coming.
Did you inform the other?
Other side is not here. I was waiting for them since morning. They are not there.
Unless you inform.
No, you yeah. I will be waiting in the morning. They are not there. Yeah,
There is no problem on my behalf. But
no,
okay, we'll call the matter then.
What is your lordship?
Yes.
Lordship, this case is filed for quashing the ex parte order judgment and order dated 3rd of October 2023, passed by the Learned District Judge Sibsagar in mixed guardianship case number 8 of 2022, and also quashing for the guardianship certificate issued on 9th of November 2023.
Yes.
Lordship, the ex parte order was actually passed without following the rules laid in CPC, Lordship. Lordship, the appellant never received any summons by post and by the Learned Court below. Though in the order dated 9th of October 2023, it is reflected that the summons was duly served upon the appellant. But the notice was summoned returned unserved, and it was written that the address is not known.
Where is that order?
Order is Page number 40, page number 56.
Number?
Number 56. Okay. 93. Page number 56, your lordship. Order dated 96. May I read the order?
Yes.
Learned counsel for the petitioner is present. Learned counsel for the petitioner has filed a petition today, white number 276 of 2023, under order rule 5. Under Order 5, Rule 20 of CPC, praying for publication of the notice summoned to the opposite party through local daily newspaper by way of substitutive service. I have gone through the case record. It appears that notice issued upon the OP respondent Muhammad Nasibur Rahman through registered with AD post had returned answer with a note on the envelope as not known. Heard learned counsel for the petitioner on the petition number so and so dated 9th March 2023. In view of submission put forward by the learned counsel for the petitioner, prayer is allowed. Petitioner is directed to publish the summons to the opposite party, namely Nasibur Rahman, in two widely circulated newspapers. And among the two newspapers, one must be in an English newspaper and another one in a local language newspaper.
Therefore, notice was published in the newspaper.
Yes, Your Lordship. Notice was published in a newspaper, in one in Dainik Janambhumi for 30th March 2023, and another was in Assam Tribune.
So what wrong with the order passed by the learned?
Lordship, actually, the substitutive mode, the order of substitutive mode of service was passed too mechanically, Your Lordship, without following the rules and provisions passed in CPC, Your Lordship.
What is the procedure?
Procedures laid down in Code of Civil Procedure, Your Lordship. In the, Your Lordship, order Rule 12. Order 5 and Order 5, Rule 12 of CPC, Your Lordship. May I read the rule?
Order 5 to Rule
12. Yes, sir. Service to be on defendant in person when practicable or on his agent wherever it is practicable. Service shall be made on the defendant in person unless he has an agent empowered to accept notice, in which case service on such agent shall be sufficient. And also, Lordship, Order 15, which says that when service may be on an adult member of the defendant's family, where in any suit the defendant is absent from his residence at the time when the service of summons is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence within a reasonable time, and he has no agent empowered to accept service of the summons on his behalf, service may be made on any adult member of the family, whether male or female, who is residing with him. And Your Lordship, also Rule 17. Lordship, Rule 17 says that procedure when defendant refuses to accept notice or cannot be found, where the defendant or his agent or such other person as aforesaid refuses to sign the acknowledgement, or where the serving officer, after using all due and reasonable diligence, cannot find the defendant who is absent from his residence at the time when service is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence within a reasonable time, and there is no agent empowered to accept service of the summons on his behalf, nor any other person on whom service can be made, the serving officer shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the respondent ordinarily resides or carries on business or personally works for gain, and shall then return the original to the court from which it was issued, with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy, the circumstances under which he did so, and the name and address of the person, if any, by whom the house was identified and in whose presence the copy was affixed. Lordship. Yes.
That the report was that the notice the defendant that report
Not
on
so.
the envelope that not known.
Not so, Your Lordship. Your Lordship, but in that address, the defendant actually resides, and prior to that and after that, communications were made to the defendant in the same address, Your Lordship. But exactly that notice was, that court summon was, they only served the sub notice only for one time, and that notice was came with a note that not note. How can it be possible, Your Lordship?
So have any document that subsequently yet that is not what
Beg your pardon, Lordship?
do you have any proof that subsequently notice was served upon in any other or in the
Yes, Your Lordship. There is proof, Lordship. Lordship, it's a notice dated 21/11/2022, which was sent to the appellant by the advocate of the respondent, stating about her talake khula. But the appellant did not receive the notice. In the said notice, though the postmaster Sifsagar head office resorted. That's true. Yeah. Lordship, page number 43, annexure F. 43.
Yeah.
Here is a notice by the advocate of the respondent to the appellant. To the appellant.
That's why where is the proof of receipt of this notice by the petitioner hearing in the same address?
Lordship, there is a report at page number 48. The report is postmaster's report. Is in response, the report says that in response to your application dated 1/01/02/2023 regarding above subject, it is to inform that the RLUR has been delivered to the addressee on 28/11/2022 as per tracking report.
But wherefrom it can be ascertained that the address of this consignment and also the address of the notice as mentioned the order dated 9 by the district judge is same.
Yes, same address, Your Lord.
How do you establish it? Where is the document?
Your Lordship, the address of the Your Lordship in on page number 81 is the annexure N. It is the petition of guardianship, petition 1 guardianship case was also filed by the appellant against the respondent before the Lanet Family Court, Kamrup Metro, Your Lordship. Your Lordship, at that moment, the appellant didn't know about the ex parte judgment and order passed by the learned district judge Sibsagar. Lordship, the petition is annexed as Annexure N, and it is in page number 81, Lordship. The page number 81 also, the address of the appellant is the same address where he resides, where he still resides in.
Have you gone through the record of the trial court, the record of the district judge?
No.
No.
Yeah.
Really, uh, both of the case. That yes, the assignment of the what is the third in his letter dated 21/11 has stated about delivery of the assignment. Also regarding the notice that has been mentioned in the order dated 19. We'll take it up after some time.
There is one CRP and one RSA, Lordship. CRP filed by me, Lordship, by the decree holders, and RSA filed by the judgment debtors, Lordship. May I start with the CRP, Lordship?
Against the same judgment and
Yes.
decree.
Against the same judgment and decree, Lordship.
How CRP and
Lordship.
both are maintained.
Yes, Lordship. Item 43 is CRP against an order passed by the executing court in favor of a third party, Lordship. Lordship, may I take your Lordship to the plain portion, Lordship? I'll start from the CRP, Lordship. Page 13, Lordship. In the CRP petitioner, he is the plaintiff, Lordship.
Both the parties are ready.
Yes, Lordship.
Ready. My submission is that if RSA goes, CRP will not stand.
Pardon?
If RSA is allowed,
then CRP
will not stand.
As per their contract.
Because we have come up for secretary that decree law in the RSA.
If your Lordship wants to hear the regular second appeal first, I have no objection, but Lordship, it is the item number 43 has been listed the CRP, Lordship. In CRP, what happened, Lordship? We are the petitioners are the decree holder, Lordship. Our suit was for right title, interest, and confirmation of possession and permanent injunction. Suit was dismissed. Then we preferred an appeal. The appeal was allowed, Lordship. Thereafter, an execution petition was filed for executing the permanent injunction portion of prayer, Lordship. In that execution petition, one application was filed by the third party, praying that this is the plot of land where the Lakshmi Mandir has, Lordship, ownership. That petition was rejected by the learned executing court, and when the third party filed a misappeal, the appellate court reversed that finding and allowed to proceed with their right title, Lordship. Against that order, I have filed this regular CRP, Lordship. And while issuing notice, that order was remained allowed to be stayed, Lordship, by this court on 27, 2018. Thereafter, both the matters were taken together, Lordship, for this final decision.
Okay. RSA.
Let me start RSA Lordship.
And RSA, Lordship, he is the appellant, my learned friend will start, Lordship. that your lordship can kindly go through the order passed in the CRP, that is 27/2018. A small synopsis was given in that order.
Lordship. This RSA was admitted with the following substantial question of law. Whether the reversal of the findings in issue number 6, 7, and 8 of the learned trial court by the learned first appellate court are proper, and if not, whether the same amounts to perversity. Any other substantial question of law that may be formulated at the time of hearing. Before start, Lordship, I would like to take your Lordship to the WS at different number at page 5 of the appeal memo of the RSA, Lordship.
Wait, but I thought the method. I did that.
I could not pick up the phone, they are not picked up, they are not identified.
Oh, but that is maybe.
Yeah, Tuesday, you know. Twelve so far. Respondent. Kindly give me the liberty to take copy of the memo of appeal from the court.
Final
31
order is
Otherwise, they said it's a recording.
of filing an application before the registry is definitely they will provide you the third page copy. Yes.
I am on the point of Lordship regarding formulation of, in my humble submission, Lordship, I am taking to Lordship that another substantial question of law regarding the non-joinder of the necessary party. Before that, Lordship, coming on the factual part, Lordship, in the WS, there are the gist of the case, Lordship, is that plaintiffs have claimed that they are possessing the land under from the Bijniraj estate, which was subsequently acquired by the government of Assam for last 40 years. Therefore, the government land was made to the land government, khas land, but they continued their position. And in the year 1991, when the respondent, the appellants here, have stolen away, cut away some bamboos, they have clouded that, think that their title was clouded, and accordingly they have come up with the suit for declaration of right, title, interest, and position. According against that, the defendants, who are the private persons, 6 persons, they have filed their WS with a specific plea. Lordship may come at 55 of the appeal of RSA. At para 5, Lordship, the defendants have taken a specific plea. Page 55, para 5. May I read, Lordship?
Page
55, para 5. This is the WS submitted by the defendant number 2, 3, 5, and 6.
Yes.
That the suit is bad for non-gender of necessary and proper party. The suit land has been being possessed by the managing committee of the Lakshmi Mandir, Lalmati. The peoples of entire Lalmati village and the neighboring areas are the general members of the Lakshmi Mandir committee. More than 100 Hindu families are performing their pujas in the Lakshmi Mandir every year since the days of Bijniraj estate. As such, all the peoples of Lalmati village and the neighboring areas have interest in the subject matter of the dispute, and as such, they are all necessary and proper parties in the suit. The plaintiff has not implemented all the peoples as parties. As such, the suit is bad for non-gender of the necessary and proper parties and liable to be dismissed. On this plea, Lordship, Learned trial court has framed an issue number 3 at page 17 of our appellate lordship. Issue number 3, sorry, this is at page 15 lordship. Issue number 3, whether the suit is bad for non-gender of necessary party. At page 17 lordship, learned trial court has given a complaint findings lordship. Secondly, the defendants have taken in the plea that suit is according to the defendants, present suit land is bad for non-gender of parties because the suit has been possessed by the managing committee of the Lakshmi Mandir, Lalmati and peoples of Lalmati area. Then in this regard, I have gone through the testimonies of DW1, DW2, DW3 and the findings comes lordship. Secondly, the plaintiff has prayed for claim no relief of the Mandir aforesaid, but during the local inspection conducted by my learned predecessor on 6/5/1992 and the memorandum prepared thereon goes to show that existence of Lakshmi Mandir. So in my opinion, the interest of Lakshmi Mandir is too involved in this case. But since no relief is claimed against them, I am of the opinion that suit is bad for non-gender of the party. This is the specific finding lordship. But thereafter, but not bad for non-gender of necessary parties and suit will proceed. Accordingly, the issue decided in negative. Both the findings are contradictory lordship here. This finding has been affirmed by learned first appellate court. And this finding has some relation with the CRP IO.
Which part of the finding contradictory?
This part, suit is non-gender of parties. Suit is bad for non-gender. One part, learned trial court is saying. Learned trial court is also saying that during the local inspection conducted by my learned predecessor on 6/5/92, it is the third paragraph lordship at page 17. Thereon goes to show that existence of Lakshmi Mandir. This is the case of the defendant. That they were no way connected with the suit, but the suit land possessed by Lakshmi Mandir.
But admittedly, no relief has been claimed against the Mandir.
Because the suit started on the plea that these 6 defendants have cut away some bamboo. They have neither claimed their possession, they are neither the owner. It is the Lakshmi Mandir lordship, managed by a managing committee, is possessing the suit land since 100 years, more than the period. So Lakshmi Mandir itself is a necessary party to be represented by its managing committee lordship.
But admittedly, no relief is being claimed.
Yes, lordship.
That,
But they are claiming for they are claiming for right title in interest and possession, which they have not. On the date of filing of this, they are out of possession. It is possessed by the Lakshmi Mandir. So, in my humble opinion, lordship, as an issue has been framed, specific findings are there.
There is connection.
No, it has not been framed, but a window is open, kept open, lordship. A window is kept open, lordship. That's why I have pointed out this, lordship. And any other substantial question of law that may be formulated at the time of hearing.
When the non-gender of necessary party will affect the outcome of the.
Because ultimately they have come up with this CRP lordship for declaration of permanent injunction, which I will come in the while replying the CRP lordship. In the guise of that permanent injunction, they want to evict the Lakshmi Mandir. I will show on record lordship that part when Madam will start their part. Lordship. This is one limb of my submission, lordship. Next, coming on merit of the law. On the issue number 6, 7, 8 regarding the perversity. In the trial lordship, trial judgment, Lordship. Learned trial court. At page translated copy we have given, Lordship, page 18. Issue number 6, 7, 8 taken together.
Yes.
The issues are, Lordship, before that. 6 is whether the suit land was the Toji land of the plaintiff under Moja Omari of business state, whether the suit land of Schedule A corresponding to Schedule land B, whether the plaintiff have long and continuous possession for more than 40 years. On these issues, these 3 issues have been taken up together. Learned trial court has decided, come to the finding in view of the discussions made above, issue number 6 is decided in negative. That is, suit land is not the Toji land of the plaintiff under the Moja. Learned trial court has not decided the issue number 7 and 8. In the appellate judgment, Lordship, at page 43.
The trial judge recorded a finding that for a victim.
Lordship, I am coming on that finding. Before that, it is the finding of the first appellate court, Lordship.
Page number.
That was in a reverse here.
Pardon?
Page 43, Lordship. In the top of it. The appellant side
Whether the
reverse that finding regarding
respect third or 41, paragraph number 10.
yes, started from that, Lordship. I am directly taking, Lordship, to page number 43, Lordship, last 1 to 3 paragraphs, Lordship. I have carefully considered the pleadings. Of exhibit 1, 2, 3, it appears that plaintiff has been occupying the suit land for about 40 years and he also paid revenue rent received suit land. Hence, this case was found the plaintiff came to occupy the land during Bijnera estate. The appellant side laid much emphasis on the point that land is a Toji land and after coming to the Assam State Acquisition of Zamindari Act, permanently settled states of Zamindars came under the state and under section 3 of the said act, notification was made to vest the states or tenure or writer or tenure holder in the state of Assam, and as such, the plaintiff who are the tenant under Zamindars become a tenant under the same. But here in this case, we find that plaintiff appellant failed to show his status as a tenant under the state in as much as the status of the plaintiff in respect of the suit land, Toji land, is that of an user. There is no khatiyan or patta issued in favor of the plaintiff in respect of the suit land by the state of Assam. Hence, I am of the opinion that plaintiff has failed to establish that he has right title interest over this. This is the finding so far concurring. But in the next last paragraph, Lordship, however, I find that plaintiff have been able to establish that he has been in occupation of the suit land measuring 2 bighas for about 40 years. It is well settled that affecting position of a person without title would make entitle him to protect his position even against the true owner. Herein, the suit, I came to reasonable conclusion that plaintiff has right of user. I find the plaintiff is entitled to retain his position. This issue is accordingly decided. So for 7 and 8 is concerned, Lordship, at para 12 on the page 44, Lord. In view of my discussions and findings under issue number 6, I find that schedule A, B are same. Not a single discussion is there, Lordship. At page 44, Lordship, para 12 of the first appellate court judgment. I also find the plaintiff has been in occupation of the suit land for 40 years and is entitled to retain his position over the suit land. According to his position is confirmed, and also find Lakshmi Mandir has no right, title, interest over the suit land. This is the issue number 9, Lordship, whether Lakshmi Mandir has right title in it. A issue was framed, Lordship, that Lakshmi Mandir has a right title. Nowhere Lakshmi Mandir is in the party, nowhere the dependents have claimed that Lakshmi. Simple plea was taken that we are not concerned, it is the Lakshmi Mandir who is in possession. And Lakshmi Mandir is a different entity, having its managing committee. For these findings, Lordship, now I, Lordship, raise a question of 4131, Lordship. While this appeal, first appeal has been decided, not as point has been formulated. On the other day, Lordship, day before yesterday, when referring to 41 mandate, Lordship, in the another case, I was sitting for this case, Lordship. Lordship has referred to one judgment, Lordship. Mathuranga, most probably, Lordship. I have also gone through that judgment, Lordship. Whether 4131 is mandated. So for this latest Supreme Court judgment is concerned, Lordship, it is that substantial compliance is sufficient. But in this case, Lordship, 4131 is not mere formulation of point. It also something more, Lordship. In this first appellate judgment, no formulation point were formulated, Lordship. Rule 31, Lordship, contains direct signature. The judgment of the appellate court shall in writing and shall state the points for determination, the decision thereon, the reasons for the decision. I am stressing on this, the reasons for decision, Lordship. Honorable Supreme Court, Lordship, in the case of Santosh Hazari, Para 15 has categorically pointed out that first appeal is a valuable right. The task of an appellate court affirming the finding the trial court is an easier one. The appellate court agreeing with the view of the trial court need not restate the facts, effect to the evidence or reiterate the reasons given by the trial court. Expression of general agreement with reasons be given by decision which is under appeal could ordinarily suffice. We would, however, like to sound a note of caution. Expression of general agreement with the findings recorded in the judgment under appeal under agreement findings recorded in the judgment under appeal should not be a device of camouflage or camouflage adopted by the appellate court for shrinking the duty cast on it. While writing a judgment of reversal, the appellate court must remain conscious of two principles. Firstly, the findings of facts based on conflicting evidence arrived at by the trial court must weigh with appellate court, more so when the findings are based on oral evidence recorded by the same presiding judge who authors the judgment. This certainly does not mean that when an appeal lies on facts, the appellate court is not competent to reverse a finding of the facts arrived at by the trial court. As a matter of law, if the appraisal of the evidence by the trial court suffers from a material irregularity or based on inadmissible evidence or on conjectures and surmises, the appellate court is entitled to interfere with the findings of the facts. This rule is nothing more than a rule of practice that when there is a conflict of oral evidence of the parties or any matter in issue, and the decision hinges upon the credibility of witnesses, then unless there is some special features about the evidence of a particular witness which has escaped the trial judge's notice, or there is a sufficient balance in probability to displace his opinion as to where the credibility lies, the appellate court should not interfere with the findings of the trial judge on a question of fact. Secondly, while reversing a finding of the fact of the appellate court must come into close quarters.
So there was no elaborate discussion.
Yes, Lord. No discussion at all, Lord.
Maybe, but the current hospital has light up it.
I'm coming on that. While discussion on issue number 6 based on only one document, Exhibit 1 Toji, and the evidence of PW1 only, because they have adduced 3 witnesses, PW1 to 3, 2, 3 they could not produce for cross-examination, Lordship. PW1, if your Lordship goes through the trial court record, Lordship, there was a cross-examination of PW1. Was reserved on 20th August 2003. A order was there, Lordship, in the order sheet also. In the order sheet of the 20th August. PW1, Lordship. It was reserved, rest reserved 20th August 2003. A specific order was there in the order sheet, Lordship. It was continued for 3 or 4 days. Subject to correction, Lordship. PW1, Lordship. That was reserved on 20th August 2003, Lordship. Thereafter, he never turned up for further cross-examination. Subject to correction, this is, Lordship. I have gone through the order sheet. Order dated 3/10/2005. Evidence was closed, plaintiff's evidence. Then again, a prayer was made, a last chance was given with cost, but due to non-appearance again on maybe 21st page 37 of the order sheet, most probably, Lordship, if I am not wrong. They failed to bring the witnesses. Evidence was closed. So virtually no PW1. One is order 3/10/2005, Lordship. It was closed, a chance was again given, again they failed. So 10/1/2006, Lordship. The plaintiff never turned up.
With the PW1,
The plaintiff, Lordship. Hari Prasad Nath, Lord.
But in the
I have the certificate copies, Lordship, with me. At cross-examination of at page 6 of the cross-examination part, Lordship. The last line, কিমান খাজনা দিছো মনত নাই মাত্ৰ দুখন খাজনা ৰচিদ আদালতত জমা দিছো মোকৰ্দমাত মই page number 6 of this, Lordship. I have this copy, Lordship, Xerox copy. It was serial at page, maybe at 9, most probably. Rest reserve. This August 2020. Hari It is lordship of midday, injunction case, lordship. This evidence is of injunction, lordship.
What fight?
This is of midday case, injunction matter, lordship, evidence of this case 29/91, lordship. This is, lordship, I am giving, yes, yes. Yes.
Okay.
May I take over to lordship to order dated 3/10 order sheet of the.
Yeah.
It was last reserved on 20th August. lordship. Order dated, lordship, 3/10/2005, lordship.
Yes.
And then again 10/1/2006. Again 10/1/2006. Another chance was given after closing of this 3/10/2005. But 10/1/2006 finally closed, case was fixed for DWH. Now, lordship, coming on fact, even if taking this evidence, this part of evidence, whatever admissible, lordship, according to my submission, lordship, I am of the humble view, plaintiff's evidence, there is no evidence of plaintiff. Even if.
Why?
Process, no further process did not turn up for further cross, lordship.
But
That's why I am saying, lordship, even if this has been taken on record, lordship, the only plaintiff's evidence is that in the chief, lordship, is এই জমি মই বিজনেস স্টেটৰ পাট্টালৈ 40 বছৰৰ অধিক কাল ভোগ দখল কৰি আছো, except this one line evidence. He failed to substantiate his possession of 40 years or more. Against this evidence, the defendants have adduced two witnesses, Lordship, DW1 and DW2.
But whether you have been able to deposit the
Yes,
part of
Lordship. Yes, Lord.
evidence.
Yes, Lordship. We have totally denied.
Where?
I am coming on, Lordship. It is in the evidence of PW1 and 2, Lordship. DW1 and 2, sorry, Lordship.
Cross-examination of it, where you have
During the cross, Lordship, we have entirely denied. More জমির 2 বিঘা মান পশ্চিমে তেওঁ ক'ব বিচাৰিছে Lordship, he does not know his land first. I will demonstrate, Lordship. প্ৰকৃতপক্ষে এইটো লক্ষী মন্দিৰৰ জমি নহয়, মোৰ জমিৰ 2 বিঘা মান পশ্চিমে লক্ষী মন্দিৰৰ ঘৰ। I am reading page number 3 in the chief, Lordship.
Yes.
We have given a better evidence, Lordship, regarding our position. No, that is the first question. That is no cross-examination, Lordship. One part, we have not come upon that part, Lordship, because we have struck on the documents. So for cross-examination, we have done.
That part of it.
Yes, Lordship. বিবাদীয় মাটিৰ ওপৰত এটা লক্ষী মন্দিৰ আছে, তেওঁ স্বীকাৰ কৰি আছে, Lordship. উক্ত লক্ষী মন্দিৰটোত গাঁৱৰ ৰাইজে পূজা কৰে। Page 4. Look, cross-examination, Lordship. In title suit. Page 4, first line, Lordship. বিবাদীয় মাটিৰ ওপৰত এটা লক্ষী মন্দিৰ আছে। উক্ত লক্ষী মন্দিৰটো গাঁৱৰ আটাইবোৰ মানুহে পূজা কৰে। লক্ষী মন্দিৰৰ কাষতে এটা এখন আৰু লক্ষী মন্দিৰ সমিতিৰ সম্পাদক সভাপতিক এই গোচৰত পক্ষ কৰা নাই। তেওঁলোকে মাটিখিনি নিজৰ বুলি দাবী কৰে। আৰু উক্ত কাৰণে এই মোকৰ্দমাটো কৰিছো। লক্ষী মন্দিৰৰ সদস্য সভাপতি সম্পাদক সভাপতিক এই মোকৰ্দমাত পক্ষভুক্ত কৰা নাই। What better evidence can come from this side? That বিবাদীয় মাটিত লক্ষী মন্দিৰ আছে, লক্ষী মন্দিৰ ৰাইজে পূজা কৰে, আৰু তেওঁলোকে নিজৰ বুলি দাবী কৰে। Apart from this evidence, Lordship, yes, it is the first line, Lordship. It is in Hopotpatra, the first page of the chief, examination in chief. That is only one line. So for his position, claim of position, which we are all along reverting. There are two of the evidence in chief, Lordship. এই জমি মই বিজনেছ ষ্টেটৰ পৰা পট্টন লৈ প্ৰায় 40 বছৰ অধিক কাল ধৰি ভোগ দখল কৰি আছো। This is his claim.
a copy of the plain part.
Yes, Lordship. Copy of the plaint is
51.
page 51, Lordship.
51, Lordship.
Page 51 to 54. At page 52, para 4, Lordship. The plaintiff has long continuous possession upon the scheduled land since more than 40 years.
Yes, according to you, by this prosecution, you will deposit the
Not only by,
of the
yes, Lordship.
PW1.
Yes, Lordship. That part we have also adduced evidence in support of our plea that it is the land in question is possessed by Lakshmi Lordship. We have given two witnesses, DW and DW2. DW1 in his chief at para 4, Lordship, categorically mentioned the plaintiff never owned, possessed the suit land. The plot of land measuring 3 biga 1 kata 0 lesa, here the suit land is 2 biga of this same dak, had been possessed by the Lakshmi Mandir managed by the peoples of Lalmati village since the days of Bizniraj state continuously and peacefully without any interference from any quarter. Then there was a Pakka well situated in the Supland is old and more than 60 years which is dug by the villagers of the Mandir. The Lakshmi Mandir is in existence since the days of Bizniraj state. the plot measuring 3 bigha 1 kata covered by Dag number 50 recorded in the name of the Lakshmi Mandir. During the cross of the DW1 lordship, the dependents has brought some interesting point, lordship. They again confirming our position.
Examination of
DW1 lordship.
updated.
At page 3, the cross-examination part, lordship. Cross-examination part, handwritten part, lordship.
Yes.
Page 3, Lakshmi, the learned court on 6/5/1992 conducted local inspection upon the suit land. My learned engaged advocate as well as the learned advocate for plaintiff during the local inspection were present. In the local inspection report, the court has stated that the suit land stands in the eastern side of Abhayapuri, Malegaon Road. The schedule of the suit land is mentioned as North Jagannath Mandir, South path for goats and cows, East grazing field, West Abhayapuri, Malegaon PW Road. The three sides, that is East, West, East and South side of the suit land was covered by the bamboo wire and bamboo post. Our dispute is not related to the Jagannath Mandir. There is no dispute regarding the north, east, west of the suit land. There is also no dispute of the southern side of the suit land. There is also no dispute on the eastern boundary of the suit land. There is PWD road on the eastern side of the suit land, and there is no dispute regarding the existence of the road. The Lakshmi Mandir is situated there. It has been findings of the larger trial court has mentioned in its judgment, lordship, that there is a local inspection, and the learned judge, civil judge or Munsif, went there and find existence of the Lakshmi Mandir, lordship. Now, during cross at page 4, lordship, they have developed one new story by giving a suggestion. It is not a fact that the Lakshmi Mandir has been land of the north of the suit land. In their plate, they have never mentioned that.
Which part?
At page 4, lordship, last ninth line from last, lordship. It is not a fact that the Lakshmi Mandir has land on the north of the suit land. That is not their case in the plain. Same thing has been reiterated by DW2 lordship regarding the 60 years old possession, the existence of a well, Pakka well in the suit land, existence of the mandir, and the defendant side. As plaintiffs have failed to demolish this part of evidence regarding our position over the suit land. Now again on coming on the first appellate court judgment, lordship, regarding finding on the exhibit 1, on the basis of which learned first appellate court has presumed the possession. It is in the cross of PW1 Lordship at page 5, the last reserve on 20th of August 2003 Lordship. প্ৰদৰ্শক 1 খাস জমি জৰীপৰ চিঠা কিমান চনত এইখন উলিয়াইছো মনত নাই 1 নম্বৰ তৌজি প্ৰদৰ্শ 1 তৌজি নম্বৰ 875 then he comes প্ৰদৰ্শ 1 তৌজি নম্বৰ উল্লেখ নাই page 5 of the cross of PW1 Lordship. The document in which he relied. Page 5 of the PW1 Lordship. এখন তৌজির খাস জরিপর চিঠা খাস জমির জরিপর চিঠা basing on which he has claimed the right title interest Lordship. That is the singular document.
Which part you are reading?
Lordship.
Which part you are reading?
I'm reading the page 5 on the cross examination started on 20th August 2003. Hosacom প্রদর্শক 1. May I proceed Lordship? কিমান চনত এক প্ৰদৰ্শক উলিয়াইছো মনত নাই প্ৰদৰ্শ 1 তৌজি নম্বৰ 875 প্ৰদ 1 তৌজি নম্বৰ উল্লেখ নাই this is one point Lordship প্ৰদৰ্শ 1 দাগ নম্বৰ উল্লেখ নাই প্ৰদৰ্শ 1 2 বিঘা 1 কঠা মাটি আছে এটো 3 বিঘা হ'ব লাগিছিল প্ৰদৰ্শ 1 ট্ৰু কপি নে সাৰ্টিফাইড কপি লিখা আছে না জানো প্ৰদৰ্শক 1 সাৰ্টিফাইড কৰা অফিচাৰৰ সহি আছে প্ৰদৰ্শক তৌজি জমি লিখা নাই. This is the document on which he is claiming his title and learned trial court has presumed that document based on his position was declared. And to revenue receipt. So the issue number 7 Lordship, I'm again coming on the 4131 not making discussions whether these two lines are same. Not a single line has been adduced evidence, not a single line has been discussed. And once trial court saying that these are redundant, now it is the duty of the first appellate court to discuss the entire material available on record. Mere one line opinion, what the first appellate court has is the one line opinion only. Without any discussion, jumping on the conclusion.
Yes. Standard.
I'm taking to Lordship page 44 again, Lordship, para 12 of the first appellate court judgment. Lord. In view of the discussions and findings on issue number 6, I find schedule A, B are same. Not a single line has been in their issue number 6, Lordship. I also find the plaintiff has been in occupation of the land of 40 years. That is a perverse finding, Lordship, and is entitled to retain his position over the suit, and accordingly his position is confirmed. So for issue number 8, not a single mention is there, Lordship. But this issue is for what was the findings of the last first appellate court.
Your part is over.
Almost, Lordship.
Yes, madam.
And given this Santosh Hazari judgment, Lordship, duty of the first appellate court, Lordship. So far, I am keeping my right reserve, Lordship, on the replying on the CRP IO, Lordship, which is on 2197, Lordship. It's just humble prayer. The judgment deserves to be set aside. It is the first appellate court judgment, Lordship.
May I pray, Lordship, this matter may be kept as part and Lordship may take up some other time. In the time I will go through the records, Lordship, that
There was not one for the record.
no, Lordship.
Why not of the court earlier?
No, Lordship, now basically the substantial question of law was formulated on the issue number 678. Issue number 678 were discussed by both the courts below. Now my learned friend is taking up to the orders in the trial court. Lord. I have to go through the order sheet of the trial court. Lord. Or if your lordship wants to hear me, then I can start some other day. I will conclude. Lordship, because Lord, because lordship, there are some concluded. Lord.
After hearing the state, my lord may be able to conclude the case because the facts are very different. Because if my lord has gone a bit of the both the judgments of the lower court, both of them are under in possession. The question of getting title doesn't arise. State is the title holder of this case. Both the court below has found it out and has recorded in their judgment. So these cases going on from 91, just because they want to remain in possession, that's all. My lord.
I am residing there by constructing my house
whatever.
Since 40 years. Sir.
That is different. But then both the courts have come to a finding that it was Zamindari land, and after the sealing laws came into operation, the state became the owner. And since these plaintiff were the tenants of the Zamindars then, when Zamindari was going on, they became the tenants of the state. But after many years, they have to come to a fresh agreement with the state, my lord. So that they couldn't show before both the court. The appellate court found that the plaintiff is in possession. He didn't give them the title. So my lord will see the angle whether this case is going on just to remain in possession. Maybe they've got some officers have got to their place and asked them to vacate their land. My lord. So that may be the real question. So if this case is going on just to remain in possession, they should immediately be closed. 25 years, 35 years has gone past. It started in 91.
First appellate court granted possessory title to the plaintiff, lordship. And 40 years we are in possession. My learned friend is saying Lucky Mandir is having possession, lordship.
No,
that that
show
finding was negated by both the courts below. Even lordship, in dismissing my suit, that discussion is there. And only on the basis of that, while issuing notice by this Honorable High Court in CRP, the order was stayed, lordship. First appellate court's order was stayed. Now, lordship, my learned friend is representing defendants, judgment debtors, and my learned friend is representing the third party also.
That perhaps he cannot.
Lordship, that cannot, but he is representing, lordship. And on behalf of Lucky Mandir, my learned friend is arguing, lordship.
No, I have argued the RSA on behalf of the appellants, lordship.
And in CRP, your lordship,
lordship, it is our stand that we are the public, we are also the members, being a locality members, lordship.
Only,
As
lordship,
our government advocates rightly said, it is a fight for possession only. Both sides are claiming possession, lordship.
My lord,
Nobody is claiming title, lordship.
I give them leave.
Even Lucky Mandir is not claiming title, lordship.
If they close this case, I can give them leave. They can go to our offices.
Let them
let them take fresh permission, modernize all the papers. Because those Zamindar days papers, it won't do now. It's everything computerized now. So let them do everything freshly, close this case. Let them make their applications to the, if necessary, to a DC also. And of course, the police will also have to inform. And they do everything freshly, my lord, and settle this thing forever. Because the idea I get is, local officers must be wanting to get them evicted, and that's why they're in this case. But then why don't they do it? We are not really, the government is not wanting to evict them, on paper at least. So close the case. do the applications before the proper officer, modernize all the papers, and make everything legal, man.
On the records, Lordship, I can satisfy your Lordship that there is no Lordship perversity by the first appellate court. The substantial question of law was formulated whether reversal of the findings of issue number 678 of the trial court by the first appellate court are perverse. This is the final court of findings facts, Lordship. They have already discussed every aspect of the matter. Trial court though dismissed my suit, that reasoning was also given that Lakshmi Mandir has no title, Lordship, no possession, no title. And thereafter, Lordship, the first appellate court also, Lordship, held that the Lakshmi Mandir has no possession. These are finding of facts, Lordship. Both the courts held in our favor that Lakshmi Mandir has no possession, but in fact plaintiff is in possession of the property, Lordship.
That's why the appeal has come, Lordship, and the question has been framed, perversity, Lordship. And issue number 9 was framed, whether Lakshmi Mandir has right title, never claimed by anybody. Even Lakshmi Mandir is not before the court.
The third party petition was
the defendants in the suit never claimed.
Okay, you come prepared then.
One more thing, my lord, we did not file written statement in the original court. So at the second appellate stage, on September 2nd, 2019, we filed an affidavit. It is, I leave it to my lord whether my lord will consider that affidavit or not, because it was filed in the second appellate stage in the High Court.
Yes, in that appellate also they have admitted, government has admitted, yes, Lakshmi Mandir is in possession, Lordship.
And the appellate court came to the finding how the parties came into possession. So for that reason, the adverse possession will not come into play. Adverse possession comes into play when you don't have any papers and when you don't have any agreement. But here it is, the appellate court found out that they were tenants during the Zumidari time. After that, they became tenants of the state. When the state took over under the sealing laws, came to possession. So they became tenants of the state. So that is very clear, my lord. There is evidence. So now this adverse possession won't come in.
State is also admitting that we are tenants of the state, Lordship. In fact, Lordship,
there we don't have any objection.
We are saying that only we are in possession, Lordship. And since long, 40 years.
The only advice is they should make press application and modernize everything, my lord. Because otherwise there will be total confusion and the cases can't go on forever. Now 36 years have passed. 91 it started. So my lord will make everything clear, and this is very unfair, my lord, that wasting court's time 35 years in every court possible.
Moreover, Lordship, that PW cross part, Lordship, PW was cross-examined, and thereafter when he did not come forward for his further cross-examination, his cross-examination was closed, Lordship. But that order was never challenged by the defendant that no, we want
Defendant,
to
why
cross-examine him.
will challenge, Lordship, that part?
Now
in
they
our
are
favor,
taking
why
a
will challenge?
stand that cross part is not
Why
sufficient.
will challenge?
We are Lordship, satisfied that our cross part is sufficient to prove our case, Lord. So we have not challenged the order, Lord. But they are taking a stand that Lordship, that part is not sufficient to prove the case of the plaintiff. They ought to have filed a revision, Lordship, for setting aside that order.
No, after substantial cross-examination, the expert
No, that's why I am submitting the facts, Lordship. Admitting, admitting, Lordship, whatever said, I am admitting that part, Lordship.
Your Lordship can make it part of any.
The Buddha number.
I am for respondent number 2.
Government of Assam.
State of Assam, the DC.
Lordship.
Let's go for one.
I am for one, Lordship. One died, Lordship. Subsequently, we have substituted 1.1 to 1.9.
1.1. Third in part is the better. After 1 week or 2 weeks.
Any
Let me, Lordship, after 2 weeks.
Any date, Lordship. On the next date, I will go to the LCR, or if your Lordship permit, even now.
If possible, Lordship, after 15 August, Lordship.
After
Obliged,
Lordship.
In my CRP, there is an interim.
That is already finalized. Most police will not be returned. Still returnable.
Yeah.
Obliged, Lordship.
And in CRP, I have to submit Lordship many things, Lordship. Some interesting facts are going on there, Lordship. Without a decree, it is going to be executed.
Have gone to the
Yes,
order address say
yes, Your Lordship. Address is same, Your Lordship. In the TCR, in page number 16, the address of the appellant. In TCR, page number 35, there are ID cards, envelope, summons. In page number 36 also, and paper publication is in page number 37, 38, and 39 of the TCR. Chip in page number
paper 37,
38,
38
30.
paper.
Yes,
Then 39.
yes, 39.
In 39, no address is mentioned.
Paper publication. Your Lordship, able to
No,
paper.
in 39. 39 the letter, the
Later.
postmaster.
Postmaster. And also in page number 47, notice by the advocate of the respondent to the appellant.
47.
47.
No, this letter was sent, that's right, but where the address is mentioned.
Your Lordship, address is in your in our appeal memo, Lordship, in page number 45, the same notice by the advocate of the respondent to the appellant. In page number 45, 5 of our appeal memo. Lordship, this is the same address, Your Lordship, where the appellant resides. Yes.
That's
Chip
the
is the
envelope.
43
Where
is
is,
the
where is that envelope?
annexure F, Your Lordship. Page number 45 is the vernacular.
Yes. The notice.
Yes, Your Lordship. Notice in that notice the address is the same address, Your Lordship. VIP Road.
But that envelope, where is that envelope?
Page 50.
Page
50.
5.
5. Further, the
So here is the endorsement of the department that not known. RDA.
Azara Home Solution is the business enterprise of the appellant, Your Lordship. This is a shop of electrical appliances and hardware, Your Lordship. And Azara Home Solution is a very famous store, Your Lordship. This is landmark situated at the main road. VIP Road.
Address here. So, where is the document to show that any notice of was served this address?
Your Lordship, annexure of F, one notice the notice of the advocate from the respondent to the appellant, Your Lordship.
Annexure F.
Annexure F, at
Yes.
page number 43. 43.
Your petition.
Yes, Your Lordship. And the certified copy is at page number 45. The notice was sent to the appellant, Your Lordship, in the same address. and he received the
That's
same.
why it was sent, but where is the document that it was report?
That's at page number 48. There is a report from the postmaster, where it is written that in response to your application dated 1st February 2023 regarding the above subject, it is informed that the RLUR has been delivered to the addressee on 28/11/2022 as per tracking report. This is the report of the postmaster, the Sagar Post Office, which says that the notice dated 21/11/2022 sent by the advocate of the respondent to the appellant was duly served. The and the appellant also received the same, which was sent in the same address.
Where is it?
Address is that, your lordship, VIP Road, Dharapur, Azara Home Solution, Azara District, Kamrup Metro, Guwahati 781.
Letter of the
No, it is not mentioned about it. But the same was produced by the respondent side before the. The fact is that, your lordship, the appellant still resides in the same address.
but by your document,
And, your lordship,
moreover, it was published in the paper.
two newspapers, you know.
But that's why it has not
But, your
yet-
lordship, newspaper, the appellant is the last resort. It should be the last resort. But they jumped over avoiding the other step mentioned in CPC, lordship. They served the notice,
No,
they served the summons
this,
for one
rule,
time, your lordship.
you have point of 70.
Yes.
Order 517.
Yes, your lordship.
Yes, to prevent defendant to accept notice or cannot be found. So there is still report that the addressing cannot be found. And only then one application was filed for the signals allowed it.
Your lordship, as per Rule 17, where did the rule, your lordship? Where the defendant or his agent or such other person as aforesaid refuses to sign the acknowledgement, or where the serving officer, after issuing all due and reasonable diligence, cannot find the defendant who is absent from his residence at the time when the service is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence within a reasonable time, and there is no agent empowered to accept notice of the summons on his behalf, nor any other person on whom service can be made. The serving officer shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the defendant ordinarily resides or carry on business or personally works for gain, and shall then return the original to the court from which it was issued, with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy, the circumstances under which he did so, and the name and address of the person, if any, by whom the house was identified and in whose presence the copy was affixed. Your lordship, this is Rule 17. Rule 17 speaks about the affix, the notice to be, it should have been affixed on the outer space of the house of the appellant. Your lordship, but no such measures or no such efforts were taken by the respondents. They served the notice for one time, and the next day they filed a petition for substitutive mode of service, and the court allowed the same.
No, here the notice was sent by post.
Yes.
The postman find him out. Because he is not known. Where the postman will epic the notice.
Your Lordship, Azera Home Solution is a very famous place of famous shop. It is not known how the postman didn't find the place, Lordship. Actually, Lordship, the matter is actually Lordship. Apart from this case, Your Lordship, the matter is a family matter between husband and wife. Your Lordship, the wife abandoned the respondent abandoned the appellant for whatever matter was going on between them. But the wife took the decree and order expertise. The wife gave him khula talak without his notice. She also divorced him. The respondent also divorced the appellant actually. And actually the appellant did not get any chance to place his points. He did not get any chance to put out his arguments, and he was not given any opportunity to give any.
Madam, you see, in page number 50, it is mentioned
50.
This address regarding Azara Home Solution.
No,
Then
this was not placed by the appellant side. This was placed by the respondent side. Page number 48, which is the report. This is not placed by the appellant side. This report was placed before the court, and a trial court before by the respondent side. They submitted this along with the.
where it is mentioned about Azara Home Solution.
Lordship, Azara Home Solution, the address.
Where?
In case 45, which is the notice from the advocate of the respondent. Page 43, Your Lordship, the type copy. Page 43. To Muhammad Nasibur Rahman, son of Muhammad so and so, resident of VIP Road, Dharapur, Azara Home Solution, Azara, District Kamrup Metro, Guwahati, 781017.
But that's all right. But this letter was sent envelope. Where is that envelope?
Page number 50. Page number 50.
Yeah. Yes, madam.
Yes, Lordship. Lordship, this case, the respondent Lordship, she left the house of the husband on 21st May 2021. She left the house of the appellant along with the daughter to her own place at Sitara. Then from there 21 till 22 November 2022, she waited for more than 1 year, so that if the appellant would have had any interest in his daughter or his wife, he would have done up. He did not even take the effort to know whether they are still alive or not. He have not even paid a single penny or nothing.
Madam,
Then
we are not
thereafter,
merit of the
yes, about the notice, Lordship.
Yes.
Yes. Then thereafter, after 1 year, the respondent, she filed a Miss G case number 8 of 2022. She filed it on 21st November 2022. That on that day itself, she declared that talak. On that day itself, it was on 21 November 2020, she declared that talak. And the talak paper was sent to the appellant through postal. And that postal receipt is this one, Lordship, which is annexed here at page 48. So
page 48, this the postal report.
Yes.
So he have received that. Then when she filed this case, Miss G case, summons were issued twice, Lordship. Notice was issued twice. That was once on maybe, but the summons shows it is on 13 November 2021, 22. And thereafter, after they did not receive, then it was again issued on 23/11/2022. Someone was issued. Then it returned unserved. Then again on 12/1/23, again notice was issued, Lordship. Then that address shown in this envelope and the address of the appellant is the same address, Lordship. There is not even a single letter difference. So if the notice talaq have been received, and how this notice of the court was not received by the appellant, when the address has no difference at all, not even a single letter, so the notice return answer. After that, Lordship, twice it did not receive, then only the court ordered for publishing it in the newspaper. Then the court have published, then thereafter they have published it in the newspaper. Still the appellant didn't turn up. Thereafter only the case was decided ex parte, Lordship. Then in the meantime, when this case was filed, Miss G case was filed there by the respondent. Thereafter, after some month, maybe or 1 month, the husband appellant, he have again filed a guardianship case here at Kamrup, Guwahati. In that case, the respondent had appeared after receiving the summons. She had appeared. Then she have even stated before the court that one case is pending there. And moreover, she have obtained the guardianship in that case. Still the court is not dismissing this case, and still this case is lying pending here, Lordship, for guardianship. Even after filing this appeal here in the High Court, the respondent have intimated the court that appeal is lying in the High Court against this guardianship certificate. Still the lower court below have not dismissed that case.
Now we are not concerned that
Lordship. She have already obtained the guardianship through the judgment passed on 3/10/23, and the guardianship certificate she have obtained on 9/11/23. And moreover, Lordship, the child is a daughter, girl child, and now she is the age of 12. At that time she left the house, her age was 8. Then now she is 12 years old. She is quite grown up. She is not even interested to come here, to come back to the father. She will never come back. And moreover, now from 4-5 years, he did not even pay a single penny or try to inquire about his child. So there is nothing wrong in the orders of the lower court, Lordship. Twice someone was, notice was issued. After that only paper publication.
any other point?
That's all, Lordship. And now the mother of the child, she is a beautician. Now she is a makeup artist. She is residing at Tinsukia with her daughter, and she have put her daughter in a very good school at Tinsukia, Guru Tegh Bahadur Academy at Tinsukia. They both are residing at Tinsukia. And there is no irregularity, nothing in the orders of the lower court, Lordship. Because 2 times summons was issued, notice was issued, steps was taken, but address is same. There is nothing wrong in the address. If the other documents reach that address, how could the court summon did not reach? And in their paragraph only, Lordship may kindly see paragraph 8 of their petition. Paragraph 8 of their petition. They themselves have stated here how, I don't know, that the appellant begs to state that from the reading of the petition number amendment, determined, and perusal of the order sheet dated 12/1/2023, notice upon the opposite party appellant hearing was served only once. And thereafter, the court below, without taking the recourse of order 520 sub-rule 1, directly passed the order dated amount for paper publication in the local daily. There is no wrong in the address, Your Lordship. Only because they have seen that it is court's someone court's notice, they refuse to accept it. But other documents they have received. The talak document they have received, and they have stated in their case that they don't know whether when she have even declared talak. Because talak, a woman can produce by pronounce by herself in front of two witnesses, but that has to be intimated to the husband. So they have done that. She have sent the talak nama to the husband.
Okay.
So how he doesn't know? They have stated that they don't know.
Pardon?
I said Hayat.
For the
Your Lordship, I would like to put to judgment regarding similar precedents and a gist of the case, Your Lordship. May I?
As Ahmed.
order is there. Pardon it for-
Obviously.
Highly
for-
Order is there.
Yes, sir, go on.
My lord, that is in Schedule C, my lord. Schedule C.
You'll say
C.
in which paragraph of your application in the interlocutory application?
I have not stated in this.
Not listed.
No.
Then where from I will inquiry?
My lord, from instruction of my client, my lord, I have taken the instruction. As per instruction, my lord, in Schedule C, my lord, a power pump is there, my lord, 5 horse power pump, and one Bhalku tree, my lord. One Bhalku tree is there implanted by the petitioner appellant.
If there is no such environment, memo of appeal and also the interlocutory application.
That is, my lord, in paragraph 12, my lord, is there, but not, my lord, specifically it is mentioned.
Paragraph 12 of
Yes, my lord. Not I, my lord, FAO. How? Though it is not specific, but my lord, some portion of land is within the possession of the appellant. It is stated.
by the national part so on. I part paper that under order 30 was 3 expert it by the third one part for the application that if done it sometime by then it record the fact that the applicant heading is in possession of some part of the sea land.
Yes.
There is accordingly allotted when
Monday, my lord.
Monday.
Yes.
Wednesday.
Only.
So I have an instruction here, Lordship.
Respect of
So they are claim lordship that 3% promotional increment lordship.
Yes.
That file has been endorsed to the finance department.
No.
Lordship. It was endorsed on 21/7/2025, Lord. So it will take some time, Lordship. Need file number. The views on granting of 3% promotional increment to the just promoted from graduate.
only now you receive the file.
No, Lordship, here, I have been informed about this Lordship today itself, Lordship. So if they have sent it on 20, they must have processed it, Lordship.
Can you obtain verbal instruction?
Lordship may give, fix it on Monday, Lordship. I can find out as to the process, Lordship, as to.
Intention of asking to obtain instruction that if they have received the file and it is under process,
Lord.
then it may become full time.
Yes, Lord. That is what they have stated also, Lordship. So, Lordship, it will be slightly difficult to find out as to can take, because they have not mentioned which establishment A. If I can
establishment A.
Lordship will fix a date after 1 week, Lordship, in the.
To establishment A.
Yes, Lordship, yes. I have just seen it, Lordship.
Let it come on, my lord, 26th of August, my lord. And
Yes,
this time,
Lordship,
my lord,
we will tell the department, we can inform
on
the
that day, my
department
lord,
to expedite the.
either they will place the final instruction, my lord, and your lordship will, or your lordship will dispose of the matter on merit.
Or sir, be and B. N. Sharma, Lord,
Lord.
A. Soliha for the finance department. Sharma, Lord, for the part for the third dated dated by the undersecretary, the Dr. Bassam, part the undersecretary, the Dr. Bassam. The then council department of forming that E file number 67281
Lord.
was moved on 21/7/2025. The finance certificate establishment A department their view on grant department from teachers from graduate teacher headmaster with the same pay band as that pay is under process and there and not and has not yet been received by the department. And on the next of the day, later Mr. Norma Samit said the matter may get stayed after 2 weeks. that the process may be completed by the offered. Whereas taking of the submission of certain both the parties has not been and Soliha learned from obtain direction regarding the status of the application file from establishment A department contacted.
Problem.
In the event of failing to complete the process by 26th of August 5, the court will proceed further the filing.
Look. Problem.
The letter for the court says the mark annexed is filed with the court.
The time is parted, man.
That's the method.
Bless you.
24.
Material lordship. This is degree of reversal lordship.
So, can we get it in half an hour?
Whether that my can start, whether maybe Captain part matter if they can complete. It is a old painting matter, 2016.
We can start lordship and then if incomplete, then on some other day, rest of the part. Appellants are the defendants, lordship. The suit was filed by the respondent and their suit was dismissed by the learned trial court. Thereafter, first appellate court reversed lordship. Plaint is in page 8, lordship. Relevant portion your lordship will find in page 10. Paragraph 4, lordship. That by this, while the plaintiffs were possessing the suit land and receiving usufructs therefrom, the principal defendant number 1, that is the present appellate, lordship, made circulation and threatened to dispossess the plaintiffs from the suit land. In fact, cultivation period, while the engaged laborers of the plaintiffs were plowing over the suit land, the defendant number 1 and his group threatened the laborers and also threatened to dispossess the plaintiffs from the suit land. In these circumstances, the plaintiffs number 3 on behalf of all the plaintiffs filed a case in the court of learned B. Datta ADM Karimganj, which was numbered as case number so under section 144 CRPC. Said case was subsequently dropped for expiry of status statutory period. That by appearing in the above stated case number 344 M of so, the principal defendant number 1 submitted his written statement objection on 14/8/2006. Going through the said written statement objection, the plaintiffs could know that the principal defendant number 1 claiming the suit land allegedly gifted to him on 11/3/1966 by one Giriram Suklaboidya and allegedly by order dated 4/7/1967 in DP case number 224/1964 before the ARO Karimganj first order for recovering the name of the principal defendant number 1 in record of rights in respect of the suit land. The plaintiffs collected said documents and order. That on perusal of said documents and order, the plaintiff could know that said DP case number 224 of 1964 was allegedly filed against the father of the plaintiffs number 2 and 3. It needs to mention here that said Sri Rasharaj Das, the father of the plaintiffs number 2 and 3, died before 1964. As such, his name is not available in the electoral roll of 1966. More so, above stated alleged donor Giriram Suklaboidya was never Nankar or Jogdar of the said Rasharaj Das or his predecessors. So, Giriram Suklaboidya never possessed the and he had no alienable title whatsoever for alleged gift in favor of the principal defendant number 1. As such, alleged gift being number 757 dated 1966 is mere paper transaction ab initio void liable to be cancelled. Likewise, alleged order of ARO Karimganj dated 4/7/1967 in DP case number so and so for recording the name of the principal defendant number 1 in Khatian in respect of the suit land is ex parte illegal, ab initio void and liable to be cancelled. So on this basis, Lordship, they prayed prayer portion page 12. For declaration that the plaintiffs and pro forma defendant numbers 5 to 10 have their title and possession in Asmali over the land described in the schedule below through inheritance. For confirmation of possession of the plaintiffs and the pro forma defendant number 5 to 10 over the land described in the schedule below in Asmali. For declaration that the principal defendant number 1 has no rights and possession over the land described in the schedule below. For declaration that mutation of name of the principal defendant number 1 made in Khatian in respect of the land described in schedule below by the principal defendant number 2 to 4 having no basis, illegal, inoperative and liable to be deleted by correcting the record of right. For declaration that the registered deed number so and so of Bhangabazar SR office is mere paper transaction, illegal, inoperative and liable to be cancelled, and sending the decree to the SR Bhangabazar for noting the name in concerned volume book. For permanent injunction restraining the principal defendants number 1 from peaceful use, occupation and enjoyment of the land described in the schedule below by the plaintiffs and pro forma defendant number 5 to 10 in Asmali. So their case is that, Lordship, behind the back of the father, Lordship, their father, Rasharaj Das, is DP proceeding was initiated by Giriram Shuklabaidya in his name. And Giriram Shuklabaidya died in the year 1964, but order was passed in the year 1966, allowing the name of defendant number 1 to be recorded in the record of rights, Lordship. So that is their claim, Lordship. On these grounds, they have filed this plaint, Lordship. We have filed our written statement, that is Annexure 14. Sorry, page 14, Lordship. Page 17, paragraph F, Lordship. That the plaintiffs have no possession over the suit land and has no title over the suit land. The plaintiff even did not identify the suit land in its boundaries. The plaintiff number 3, by stating false boundaries and by showing an area of 0.69 acre of land in dark number so and so by putting some boundary, illegally claiming the suit schedule land, and by putting false and fabricated statements by a petition under section 144 CRPC against answering defendant number 1 in the court of Srimati B. Datta ADM Karimganj for drawal of proceeding against the answering defendant number 1. The learned court of ADM Karimganj registered case under section case number 344 and issue notice upon defendant number 1. The answering defendant number 1 submitted objection in case number so and after hearing the parties, the learned ADM Karimganj was pleased to drop the proceeding by the order dated 29/2006. That in the suit land and other land, Giriram Shuklabaidya acquired Jot right by right of inheritance from the predecessors of plaintiffs and was in possession over the same and thereafter gifted to defendant number 1. The defendant number 1 maintaining right title and possession over the suit land along with other land. The suit land and other land was mutated in the name of answering defendant number 1 and the defendant number 1 got Kacha Patta also. The answering defendant number 1 maintaining possession over the same and producing petty thereon with knowledge of all in adverse, including the knowledge of plaintiff. That the gift deed number so and so is a valid document, the DP case number so and so was not collusive order and has full force in the eye of law and is valid order passed by the court. The plaintiff has had no possession and title over the suit land. The plaintiffs got up story filed this suit against the answering defendant number 1 just to harass the answering defendant number 1. The plaintiffs are not entitled to it. So, Lordship, denying the claim of the plaintiff, written statement was filed. Issues page 20, Lordship. Eight issues were framed, Lordship. And preemptory hearing, at the time of preemptory hearing, plaintiff side adduced the evidence of Ratish Das, Asaddar Ali and Anupkumar Roy as PW 1, 2 and 3. Defendant side adduced the evidence of Shyamal Roy, Akhilesh Mia and Rasharaj Kumar Das as DW 1, 2 and 3. Issue number 678, Lordship, I am reading. Paragraph 8. All these issues are interrelated and hence they are clubbed together for the sake of discussion. Plaintiff side is claiming the suit lent on the strength of a working khatiyan issued in favor of their predecessor. On the other hand, defendant number 1 is claiming the suit lent on the strength of one gift deed alleged to be executed by one Giriram Shuklabaidya. Now plaintiff side is denying the right title or possession of this Giriram Shuklabaidya over the suit lent. The contention of the plaintiff side is that since Giriram Shuklabaidya had no right and title over the suit lent, the gift deed alleged to be executed by him in favor of the defendant number 1 is void, illegal, and as such liable to be cancelled. As per contention of defendant side, one draft publication case number 224 of 1964 was filed by Giriram Shuklabaidya against the predecessor of the plaintiffs and pro forma defendants, and in that case the then ARO passed an order to record the name of Giriram Shuklabaidya in the record of rights. Secondly, as the suit lent was gifted by said Giriram Shuklabaidya in favor of defendant number 1, the suit lent was subsequently mutated in the name of defendant number 1 and he also got the final khatiyan in respect of the suit lent. So, Lordship, as per order dated 1967, Lordship, the order was passed in the year 1966 or 7, Lordship. That the name of defendant number 1 was incorporated and they filed the suit, Lordship, in the year 2006. Now, para 10, Lordship, page 22. So, clearly, title of plaintiff depend upon the validity of the gift deed 11/3/1966 and the order of ARO in DP case number so-and-so. If plaintiff is able to prove that the gift deed number so-and-so and the order dated so-and-so are illegal, void, and collusive, then only plaintiff side can establish its case. PW1 in his evidence stated that after the death of his father Rasharaj Das, he along with pro forma defendant number 5 to 10 have been maintaining possession over the suit land by cultivating the same through engaged laborers. They are also paying the land revenue regularly. PW1 further stated that while principal defendant number 1 threatened to dispossess the plaintiffs and pro forma defendants from the suit land, they filed a case in the court of ADM so-and-so. After going through the said written statement, plaintiffs came to know that defendant number 1 was claiming the suit land on the strength of a gift deed allegedly executed by one Giriram Shuklabaidya on 11/3/66. In DP case number so-and-so, the ARO Karimganj passed order for recording name of defendant number 1 in record of rights in respect of the suit land. The DP case was filed against Rasharaj Das, but he died in the year 1964 and his successors were not impleaded in that case. Giriram Shuklabaidya never possessed the suit land and he had no alienable title. As such, the deed of gift as well as so-and-so are illegal and liable to be cancelled. In his cross-examination, PW1 stated that he got kachapatta in respect of the suit land but admitted that he did not submit the same in this case. He further admitted that he did not get any patta in respect of the suit land and in the settlement record the name of defendant number 1 is recorded. PW1 admitted in his cross-examination that one Giriram Shuklabaidya was allowed by the plaintiffs to reside in the homestead situated in the land covered by dag number 1007 and 1008 and Roshamoy Chandra Chando was residing in the said homestead. Roshamoy Chandra Chando is the defendant number 1. So they admitted that we are residing there, Lord. Residing in the said homestead for more or less than 30 years. He admitted that land of Exhibit 5 is not related to the suit land. PW1 also admitted that he did not submit the death certificate of his father in this case. PW2 Asaddar Ali stated in his evidence that plaintiffs and pro forma defendants number 5 to 10 are the joint owners and possessors of the suit land in Esmali and they are maintaining their possession over the suit land. He also stated that the suit land has been regularly cultivated by him since long as Bhagidar of the plaintiffs, and Roshamoy Chandra Chanda never possessed the suit land nor cultivated the same. In his cross-examination, PW2 stated that he did not know the dag number, Khatian number of the suit land, and also had never seen any document in respect of the suit land. He also denied to lots of suggestions advanced by the defendant side. PW3 was summoned to produce the admission register of Vidya Niketan School, Karimganj. He stated that as per admission register, Ratish Das was admitted in that school on 2/1/1964 and his father's name is mentioned as late Rasharaj Das. PW1 also stated that Exhibit 7 was prepared on the basis of admission register. Exhibit 7 is the certificate issued by the principal SB Vidya Niketan Higher Secondary School, wherein it is mentioned that on 2/1/1964, that is at the time of admission of Ratish Das, in that school his father was not alive. In his cross-examination, PW3 stated that counter signature of school inspector is required while issuing certificate from the school. However, it is not necessary in each and every case. He also denied to lots of suggestions advanced by the defendant side. Plaintiff side also exhibited the certified copy of electoral roll of 1966 as Exhibit 4 to show that the name of Rasharaj Das was not recorded in the said electoral roll since he was not alive. DW1 Shyamal Chandra stated in his evidence that in the suit land and other lands, one Giriram Shuklabaidya acquired Jodh by right of inheritance from the predecessors of plaintiff and was in possession. The defendant number 1 has been maintaining right title and possession over the suit land along with other lands. The suit land and other lands have been mutated in the name of defendant number 1 and he got Kachapatta also. DW1 further stated that Giriram Shuklabaidya filed objection against the preparation of record of right before the ARO Karimganj in the year 1964 against Rasharaj Das, that is predecessor of the plaintiff's lordship, which was numbered as DP case number 224 of 1964. Before disposal of the DP case, Giriram Shuklabaidya gifted the suit land along with other land to Rashamoy Chandra Chanda. Defendant side exhibited the gift deed as Exhibit A and order in DP case as Exhibit B. DW1 also stated that after registration of the gift deed, Rashamoy Chandra Chanda filed a petition before the ARO Karimganj for substitution of his name in place of Giriram Shuklabaidya, which was also supported by Giriram Shuklabaidya. In the order itself, lordship, in the order of passed by the ARO, both the petitions were, lordship, recorded as petition X and Y, lordship. ARO passed an order on 4/7/1967 for mutation of the name of Rashamoy Chanda in respect of the suit land. After the death of Giriram Shuklabaidya and his wife, Rashamoy Chanda became the absolute owner of the suit land on the strength of gift deed. DW1 was stated that in the resettlement survey operation, the settlement staff found his father in possession of the suit land along with other land, and accordingly Kachapatta was issued in his favor in respect of the suit land along with other land. Exhibit C is the said Kachapatta. Defendant side also exhibited Miyadi Kiraz Patta number so at Exhibit D, which was issued in favor of Rashamoy Das. Plaintiff never possessed the suit land, and the gift deed as well as the other order of ARO dated so are valid. And in his cross-examination, DW1 stated that he could not say as to how Giriram Shuklabaidya became the owner of the suit land. He also stated that Navarani Shuklabaidya was the adopted daughter of Giriram Shuklabaidya. DW2 Roisuddin stated in his evidence that Rashamoy Chandra Chanda is the owner of the suit land and DW2 used to cultivate the said land as sharecropper. He also stated that Rishikesh Das or Ratish Das had no possession over the suit land at any point of time. In his cross-examination, DW2 stated that he saw Rashamoy Chanda cultivating the suit land since his childhood. DW3 Aklismia stated in his evidence that the suit land is situated to the north of his own land. he purchased the said land from Moinuddin by registered deed number so-and-so. DW3 further stated that he saw Rasamoy Chandra Chanda possessing the suit land since 1985, and DW3 cultivated the suit land from 2001 to 2004 as sharecropper. Rishikesh Das or Rotish Das had no possession over the suit land at any point of time. In cross-examination, DW3 stated that he saw Rasamoy Chandra Chanda cultivating the suit land for last 40 years, but could not say as to how did he become the owner of the suit land. DW4 was summoned by defendant side to prove the execution of Exhibit E and F, which are the purchase deeds of Aklis Mia and his daughter Nehar Begum. The land of Exhibit E and F are situated adjacent to the suit land. In Exhibit E, the northern boundary land is mentioned as the land of Rasamoy Chandra Chanda, and in Exhibit F, the eastern boundary land is mentioned as the land of Rasamoy Chandra Chanda. From the schedule of the plain, it is also clear that the western and southern boundary lands are of Kul Bibi, who is the wife of Aklis Mia and mother of Nehar Begum. So there is no doubt that the suit land is the northern and eastern boundary land of lands of Exhibit E and F respectively. So defendant, by exhibiting some sale deeds of the neighboring plots, lordship, tried to prove that this is the suit land and adjacent lands are purchased by the DW2 lordship. Joint counsel for the plaintiff strongly argued that the order in DP case was passed in the year 1967, whereas Rasharas Das expired in the year 1965. His legal heirs were not impleaded in the case, and as such the order is inoperative and liable to be cancelled. I have gone through the order dated so-and-so passed in DP case number so-and-so. There is no dispute as to the fact that said DP case was filed by Giriram Shuklovaidya against Rasharas Das in respect of 5 ducks. From the perusal of the order, it reveals that the case was contested by Rasharas Das and he was fully represented by an advocate in that DP case. So the plea of plaintiff that the order was not within their knowledge is not at all tenable. The case was instituted in the year 1964 and Rasharas Das died in the year 1965. So it was the duty of plaintiff side to inform the court about the death of Rasharas Das. No appeal was preferred by the legal heirs of Rasharas Das, that is the plaintiffs, against the order passed by ARO in DP case number so-and-so in proper forum. The order dated 4/7/67 remained unchallenged till date, and now after 40 years of that order, plaintiffs are praying for cancellation of that order. The last paragraph of the said order is as follows. As admitted by the parties, Sri Giriram Shuklovaidya be recorded as Dakaldar in the aforementioned dag number so-and-so. Dakal of Sri Rasamoy Chandra Chanda also goes with Giriram Shuklovaidya, although the former has not yet acquired any title. Hence, Rasamoy Chandra Chanda also be recorded along with Giriram Shuklovaidya till the status of the latter is finally decided and recorded. On the basis of this order, name of Rasamoy Chandra Chanda was recorded in the settlement records. From the perusal of the order, it reveals that the other side admitted the position of Giriram Shuklovaidya over the suit land, but in their plaintiff stated that Giriram Shuklovaidya never possessed the suit land at any point of time. The fact of gift deed executed by Giriram Shuklovaidya in favor of Rasamoy Chandra Chanda was also discussed in the said order by the ARO, but his legal heirs never challenged the validity of the gift deed before any court. No objection was filed in that court in respect of the gift deed. On the strength of aforesaid order, the name of Rasamoy Chandra Chanda was recorded along with Giriram Shuklovaidya, and Miyadi Kachapatta was subsequently issued in his favor. Moreover, periodic patta was also issued in the name of Rasamoy Chandra Chanda in respect of the suit land. And in the plain lordship, there was no prayer for cancellation of these pattas, lordship. And plaintiff own witness, they are saying that we are in possession of the suit land. As far as the possession of suit land is concerned, apart from Asaddar Ali, plaintiff side failed to adduce any other evidence to show their possession over the suit land. On the other hand, defendant side proved 2 documents that is Exhibit E and F, from which it is clear that in the year 1985 as well as in the year 1999, Roshamay Chandra was possessing the suit land. Moreover, Aklis Mia, who shares the western and southern boundary of the suit land, stated in his evidence that he saw Roshamay Chandra possessing the suit land since the year 1985. Possession of the suit land by Roshamay Chandra is clearly established in this case. What surfaces from the ongoing discussion is that plaintiff side has failed to prove that the gift deed number so-and-so and the order dated so-and-so are both illegal and hence liable to be cancelled. Plaintiff side has also failed to prove its title and possession over the suit land. Issue number 6, 7 and 8 are accordingly decided in negative and in favor of the defendants.
That the register date.
Yes, Lord. And mere saying that Lordship, there it's a collusive deeds, it will not suffice, Lordship. For collusiveness, as per Order 6, Rule 4, Lordship, specific pleading should be there. There are constitutional judgments also in this aspect. As per Order 4, Order 6, Rule 4, Lordship, if any averment is there that this is a fraud or coercive coercion, Lordship, that should be specific. And from reading the Lordship exhibit, the order passed by the ARO, I can prove that Lordship, that case was, Lordship, the respondent Rosharaj was represented in that case. His advocate argued that case, Lordship. So it is his duty as per Order 22 Rule 10A to inform the court that my client has died. May I proceed to first appellate court judgment or on some other date?
How the
First appellate
dealt with regarding gift deed?
gift deed, Lordship, the appellate court says it is during the pendency of that DP proceeding, Giriram Shuklabaidya executed. So during the pendency of any case, if any transaction was done, that is not valid, Lordship. Please pendency, Lord. And one more thing, Lordship, as Giriram Shuklabaidya already given a letter to the ARO that I do not want to proceed with this case, so that case has no value, Lordship. Lordship. Next date, I will read the first appellate court judgment.
And what is the
Apply.
Well, a date is to be required. Date to be fixed. Otherwise, part matter, otherwise it will be
last part of
August. The date may be given.
Or we
Otherwise,
can mention, Lordship, this the matter will come here only. We can mention also, Lordship. After 15th August, we can mention.
well, date may be fixed. Kindly, date may be last
If
part.
you-
Last part. On 28 or 26, 26.
I think the already a lot of
September, my lord, then my lord, it may come on 9th, my lord, now 4th, my lord, 4th.
Maybe it
No,
it should be listed within 1 month.
I just both weeks I have not.
Lordship heard the matter.
Partnered matters may be listed within 1 month. Maybe there is a
Heard, my lord,
notification.
about half an hour.
Fine, okay.
Date. Public.
Wait, please, your lordship. Lordship, let it be the matter be fixed in the month of September, lordship. Because now it's already 4:30.
Here made by method.
A date may be given.
take it.
May please your lordship. Well, we are for the respondent. I for respondent number 1 to 5 and for others
And
five
for 6 to 10.
May
For-
please your lordship.
for appellant.
Lordship, matter may be take adjourn for that, as Contracting Council PP das is not present. Out
My
of
lord, may I pray, my lord, may I pray for a date, my lord, because there is a concurrent finding, my lord. There is a concurrent finding, my lord. And, my lord, if possible, my lord, maybe 12th August, my lord, if possible. Or for
Friday, lot of matter take the 11 of the month of September.
the date may be fixed, my lord.
Or that one. The second by the-
Right.
This is not 19th August, but my very old days are before uh, the third week of September, I was 23